meeting of the Radnor Township Zoning Hearing Board. Our chairman, Mr. Falcone, is unavailable this evening, so I will be chairing this evening's meeting. Before we start, I'd like to apologize for my appearance. I had a bit of surgery this week, and I have to keep this on until Monday. So I apologize for the delay in starting. The board met in executive session with its solicitor, and we're ready to go. But before we do that, we have a number of administrative matters to deal with. The board had scheduled an overflow hearing for June 7th of this year. In light of some withdrawals of applications and continuances, we no longer need the June 7 date, so we will not be meeting on the 7th. The next hearing date, I believe, is the 15th of June. The first continuance we have is a letter dated May 18, 2001, from Nicholas J. Cornelia regarding appeal of Eastern University. That's appeal number 2488. His letter reads, Dear John, the purpose of this letter is to request that the Zoning Hearing Board continue the zoning hearing on the above scheduled matter for May 19, 2011 to the tentative overflow Zoning Hearing Board scheduled for June 7, 2011. If scheduling to the June 7th hearing is unacceptable, please reschedule to the June 15th zoning hearing. All of the parties are in agreement with the continuance. As you may be aware, the parties have been discussing a possible agreement regarding the issue before the board. Additional time is required to consider and further discuss a possible resolution. The applicant agrees to extend the time when the board can hear this matter to June 16, 2011, and further agrees that a written decision will not be required until 45 days after whenever the rescheduled hearing takes place. Thank you for your time and consideration. It would be my recommendation that we agree to extend to continue the matter until the June meeting. Does anybody have any comments? Anybody have any objections to continuing to the June? No problem. Okay. We'll continue that 2844 to the June meeting. The next administrative matter we have is a letter dated May 18, 2001 to Mr. Ryan from Nicholas A. Cousset, Jr. Regarding Zoning Hearing Board Appeal 2851. That's the Radnor Fire Company / Metro PCS Pennsylvania LLC application. His letter reads, Dear Mr. Ryan, per our discussion, please note that the applicants require an indefinite continuance from the May 19, 2011 Zoning Hearing Board hearing agenda with a 30-day notice provision for reactivation. The continuance is requested as this site will be temporarily placed on hold. Please note that the applicants waive all requirements of the Pennsylvania Municipalities Planning Code that mandate the time frame for which the township to conduct a hearing in this matter. Also, the 45-day time period to render a written decision is extended in line with the extension. As discussed, I will be in attendance on May 19th should the board have any follow-up questions. Thank you for your consideration in this matter. Is Mr. Cousset present? Sir.
Sam, good evening. Nicholas Cousset here on behalf of applicants Radnor Fire Company and Metro PCS. As noted in the letter, I had just found out this week from one of the applicants, being Metro PCS, that this site is being temporarily put on hold. I pressed Metro to see if they could give me some type of timetable, whether it be 6 months or what have you. They couldn't give me anything definitive. This will be certainly coming back. I can assure the board of that. That's why we requested the indefinite extension if the board is so inclined to grant that. If not, I'd be willing to discuss any alternatives that the board may have.
In my service on the board, I think we've granted an indefinite continuance, maybe never. So I would be inclined to continue the matter until the September meeting. Do you think that'd be all right?
September, 4 months. Would the board be amenable to 6 months by any chance? I think anything less than that, I know for I can tell you this, they will not be ready by September. And if the board does not want to do that, we are willing to withdraw it.
Maybe they want to withdraw it and just refile it when they're ready. If you were just trying to work out something with the school district like before, we can understand the situation. But since this is an open-ended, indefinite question mark.
Yeah. Oh, completely understood.
You may as well just withdraw it and refile it.
All right. If I may then on the record withdraw the request that the application be withdrawn without prejudice.
Okay. All right. Application 2851 is withdrawn.
Thank you very much.
Thank you very much for your time. Speaking of withdrawals of applications, if anybody's here on the Agnes Irwin application 2856, there was a letter sent by counsel for Agnes Irwin School, Mr. Cornelia, to Matt Bauman, dated May 11. The letter reads, "Dear Matt, I represent the above applicant. Kindly withdraw the above application from consideration by the zoning hearing board. Thank you for your time and consideration." So, appeal number 2856 has been withdrawn altogether. That leaves us with the first matter to be heard on the merits tonight will be appeal number 2854. The applicant, Lucky Dog Enterprises, LLC, care of Marty Grims, located at 200 West Lancaster Avenue, Wayne, PA 19087, and is zoned WBOD. Seeks approval to operate an accessory outdoor dining area with a maximum of 50 seats. It is proposed that outdoor dining be limited to 5:30 to 10 p.m. on weekdays and from 11 a.m. to 10 p.m. on weekends. The applicant contends that the parking requirements of Code Section 28053.12B5 do not apply to outdoor dining in the WBOD. Alternatively, applicant contends that A, the necessary parking is provided at the times when the outdoor dining would be used, and B, that outdoor dining should be permitted as a vested right or through a variance by estoppel. As advertised, the notice also provided that finally and also alternatively, applicant requests a variance from Code Section 28053.12B5 to allow the use of the outdoor dining area as described herein and any other relief required. It's my understanding, however, that the variance request has been withdrawn. Is that correct, Mr. Counsel?
Just as to that last one.
Just as to that last
And without prejudice, I think.
bit, and without prejudice, is that correct, Counsel? Okay. Mr. Brosman, floor is yours.
Excuse me, George, before you get started, I have a question. I don't have a copy of the lease showing that the applicant has the rights in the premises and the rights to file this application. Was it filed and that's not in my packet?
It was not filed, but
It
was not filed, but we're going to present it. If you want me to present that first, I can do that.
I think I think we need to do that, but I was, wondering about the posture of the case. I think we understand that you've withdrawn the one variance request from that zoning code provision, not the vested right or variance from the estoppel request. I believe that remains in play. A fairly lengthy package with a memorandum of law and some exhibits was submitted to the board just yesterday, and I've talked with Mr. Brosman. I understand that the process of discussions with the township was such that it looked like at one point maybe this wouldn't be needed. So I'm not in any way casting any aspersions or anger or shaking my finger that the material came in just yesterday. That's fine. But what I am concerned about is twofold. It's in now. I don't know if there are other parties in the case who have not had a chance to look at it or respond. And frankly, I've gone through the material. I know a couple of I believe the board members have done so to varying degrees, and I have some questions. And frankly, my suggestion is going to be that while we may proceed on the hearing tonight, that there be a continuance to at least permit the filing of briefs by other parties, and also to give me and this board a chance to go through this. This is, as I see it, is a fairly sophisticated application, and with some fairly sophisticated issues, quite sophisticated issues, and I think that it requires that additional time to permit this board to come to a conclusion and to permit any parties to participate in a meaningful manner.
We ought to ask, is anyone here intending to file an appearance in this matter, opposing it? You are going to go on the record as a party. So we do have other parties here who haven't even seen the briefs.
Township.
John, are you opposing?
Township's here also.
And are you opposing?
Well, I'm here in support of the zoning officer's interpretation, which is what's in front of you.
Should we get everybody's appearance for the record right up front?
No harm.
Why don't we just we'll let Mr. Brosman go first, and then we'll go from there.
I'll have a chance to question the other party. I obviously know who the township is, and I know they have standing.
Do you want to make your record on standing right from the jump?
It's up to you.
That's fine with me. Sir, anybody who wants to make an appearance, please come up.
Is there another mic?
There is. We have a handheld. Is it up? It's up here? No? Where's our AV guy?
To get some of those lapel mics.
Yeah. Okay, sir, can you state your name for the record?
Yes, my name is John Sheehan. I live at 409 Windsor Avenue, Wayne, PA. I've lived there for 40 years, and I also represent the Windsor Farm Neighborhood Association, which embraces the Farm Road and Windsor Avenue. Windsor Avenue basically begins and or terminates approximately where the Banbury and the Wawa location is.
Okay, 1 second.
Yes.
So let's swear him in just for now.
You raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
And would you spell your last name for me, please?
Sheehan, S-H-E-E-H-A-N.
Thank you.
So this association you represent, are you an officer of the association?
I'm an authorized representative to speak on behalf of the association.
As their attorney, or what's your
No,
status?
I'm a resident. The association is
Can
composed
he
of
appear for an
residents.
association unless he's an officer or an attorney?
I don't know the answer to
If
that.
you're I think if he's authorized, the question then becomes.
Is there a resolution of authorization or something?
It's a voluntary association. It's not incorporated. It's a voluntary association of residents, 35 families.
In my view, if he represents to us that he represents the association, the board can take that. I'm also interested in where the members of this association live in terms of proximity to the property, because that would impact standing.
They all live on Windsor Avenue and Farm Road.
Okay,
And I believe that Windsor Avenue, portions of Windsor Avenue receive notices. So I believe that they are within the, whatever the circumference is of the notification district.
It's
Whatever.
500 feet, is it not?
It's 1,000 feet.
Okay, 1,000 feet. The standing is a matter of, it's a matter of degree. The more intensive the use, the broader the radius of standing. There is case law to the effect that standing is presumed for somebody within 400 to 600 feet, and that's the quote, that's the Lauman decision. Obviously, there's testimony that some of these people receive notice, and if that's 1,000 feet is the radius, some people must live within 1,000 feet. How far is your home?
It's probably further than 400 to 600 feet, but not much further. But I believe that one of the criteria for standing may have to do with the hazardous conditions that the business poses. When I leave my house, I drive down Windsor Avenue towards Banbury. Where Banbury intersects Lancaster Avenue is just a few doors away from where White Dog Cafe is. At least several times a week, I walk from my house past White Dog Cafe and back again. So I usually drive several times a day in that area. I have no choice but to pass White Dog Cafe without going several miles out of my way. And I believe, and I will present evidence, that there are some very hazardous traffic conditions that already exist at White Dog Cafe just due to the excess intensity of use for that location.
John, for the record, it is actually not 1,000 feet, it's 500 feet. AC and R1 zoning districts are 1,000 feet.
Okay.
Okay?
So if some of these, did you receive a notice?
I did not, but I do know that in previous White Dog hearings, the hearing that was scheduled, I believe, and withdrawn last January, that residents on Windsor Avenue did receive a notice.
Okay. Mr. Bozeman, do you have any questions for the witness?
Just a few. Mr. Sheehan, you mentioned your interest in this was that you frequented Lancaster Avenue and Banbury intersection,
Yes,
and that you walked by the White Dog Cafe.
yes.
That's that's a very heavily trafficked intersection. Is that correct?
It is.
And a lot of people walk along Lancaster Avenue, don't they?
Presumably, yes. I haven't counted the people walking on Lancaster Avenue, but I walk there.
And you did not receive a notice of this hearing because your property was further than the legal limit?
I don't know that for sure. I did not receive a notice.
You did not receive
Yeah,
one?
I don't know for sure that it's that I live outside the legal limit.
Okay. And that's all I have. I object to his standing. He lives beyond the legal limit, and the concerns that he has raised are concerns that anybody in the general population would raise that are at that intersection and would walk down the sidewalk. To have standing, I think he's supposed to have some special interest in the matter, different than other citizens. So he can certainly ask questions and participate, but I would object that he be given the status of a party to this matter. And with regard to the association, I object as to those people that are beyond the distance.
Can I make a suggestion? Maybe there's a way to play Solomon here. Are you prepared to put on witnesses, sir?
I'm prepared to offer testimony in the form of exhibits and testify.
And any citizen can come and listen to this and come to the mic and state their views. But being a party has legal significance. It's different. Mr. Bozeman is objecting to your being admitted as a party. And I think maybe what we ought to do is, if you're not going to put on testimony,
I
mean, you're not calling other witnesses, right? Or are you?
I may ask questions of the applicant.
That's different. But you're not going to put on any witnesses.
No, I don't intend
The point
to.
I'm trying to make is maybe the thing to do is, if Mr. Bozeman puts on his case, we can always determine before the next hearing what your radius is, where you fall, to see if you're entitled to status. There's really no consequence to him being determined or not being determined a party today if he's not putting on a case.
And we don't even have to make a decision on standing.
That's
today.
right, and we'll know before the next hearing if you qualify to be a party. Meanwhile, you may as well give him a copy of whatever brief you have, and if he wants to file one in opposition, he can do that, but it'll all be pending the ultimate determination of whether, in fact, you are a proper party.
Yeah, that's fine. I mean, I'm obligated to make my objection for the record, as you know.
No, I understand. You did the
And,
right thing.
So we can proceed, and at some point you'll decide if he has standing.
Yep.
And also, sir, I think you should supply us also with something a little better to establish what this association is and what your standing is to speak for it.
Okay,
Are you authorized to
Right.
represent?
I'm authorized.
Okay.
Yeah, I think, you may want to submit.
And
more
why the members of the association would have standing.
Okay, I can
Okay.
do that.
Thanks.
I mean, there may be someone down the street who does live within the radius and maybe should be here.
And there may be
Yeah.
people here who do live.
Is there anyone else here who's interested in the matter?
In making an appearing as a party in the matter, as opposed to just asking questions. Okay, but do you want to appear as a party, or do you just want to make your views heard? Okay. Anybody want to appear as a party, which would entitle you to service of briefs and permit you to serve your own brief, and if this thing gets appealed to the court, you would be able to appeal it or participate in an appeal?
I'd like to preserve that right.
Okay. All right. Anybody else? Okay, thanks.
Keep in mind that, the rulings on standing, are themselves subject to appeal. If we grant standing, the applicant's counsel has properly objected to that, or if we fail to pass on it at all, that objection is raised. Also, the test is the presumption. There are cases that say 400 to 600 feet standing is presumed, but that doesn't mean that standing can't be a greater radius for a more intensive use. I mean, I think the radius of standing is less for a small addition to somebody's porch than it is for building a nuclear power plant, but it's a factual determination on a case-by-case basis. And again, we may, we're just starting to hear what's at stake and what its impact is.
Thank you.
Thank you, sir. Mr. Brosman, again, the floor is yours.
Did you want me to put in the lease? I was going to do that later. Would you prefer that I do
Well, actually, that
first?
should have been attached to the application. I think Matt should have a copy for the township file at the very least.
Okay.
Why don't we get that in now?
I can do that now.
We need to be satisfied that you and your client has standing.
Sure, understood. That's. I think I'm going to ask Mr. Grims to be sworn in. He's the principal of the entity that rents the space, and I'll ask him if he has a lease, and then I have redacted copy that I'll hand in.
Okay.
Sir, you'll raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
And state your full name for the record, please.
Martin Stephen Grims.
Thank you.
How many of you would like a copy of the lease? I've given it to John.
I'll need
Ryan.
one for the, John will need one for his file, but I'll need one for the township file.
We actually, before
Is the guy back
we go further, might want to label some exhibits right now. We have, in this matter, received, by my reckoning, two things. One is an application itself, which has the deed and a number of letters.
Mr. Ryan, excuse me, I have those marked. I was going to submit the application and my letter as A1 and A2, if that would help.
Yes,
Oh, you've
that's
pre-marked everything.
I've pre-marked.
Super.
Okay.
So if you have it all done, let's go ahead and get it all together and in the record and.
Do you want,
Yeah,
you want me to do the lease first?
Yeah.
Or the,
Well,
Okay.
What's going to be A1?
A1 is my application, which I'll give to you, and A2 is the letter withdrawing the variance.
Okay.
Should we make the lease A3?
I had already marked it A8.
Perfect.
Fine.
A8 is better.
I was going to call Mr. Grims at A8, but we can go out of order if that's okay.
All right, let's do it.
By the way, we also have in this case a letter dated May 13th from a Michael Maria of Manager Office Services, which are they're located at 137 West Wayne Avenue. Have you seen this letter?
I have.
Okay. So why don't we put get the applicant's exhibits in
We'll
first?
add that later.
And then we'll add that later.
I was looking at my papers. Was Mr. Grimm sworn in?
He was.
Okay. Marty, do you operate the White Dog Cafe restaurant that's located at 200 West Lancaster Avenue in Wayne?
I do.
And I have handed up to the board, and I'm showing you what I've marked as Exhibit A8. Is this a redacted lease? That is the lease for the White Dog Cafe to have its space at the premises that I just mentioned?
It is.
And on top of this specifically is the fourth addendum. Is this the addendum that clarifies that you also have the right to use the patio, which is the subject of our outdoor dining application?
It is.
And now I've redacted many things for the board's information. It's financial information and other proprietary information. Mr. Grims, is this lease still in effect?
It is.
That's all I have on the lease.
Mr. Grims, the redacting on page 1 of the Fourth Amendment in A and B, can you confirm that the language that's been redacted does not relate to your ability, as shown in the remaining language, to use the patio for sit-down dining, and that the seating is limited to 50 seats, that the language you've struck does not relate to that authorization, condition it in some other way? My question was this. In the Fourth Amendment to lease, at the top of the page, it says use of patio, section 3. Use of the patio shall be subject to the following restrictions. A, tenant may use the patio only during the season, capital S, and only for sit-down dining. And then it says seating shall be limited to 50 seats. This is their authorization. I guess I'd like to know what season means, but the question I have is, does any of the crossed out language limit the ability to use the patio in some way that's pertinent to this proceeding? If it's financial, it's not pertinent to this proceeding. But if there's something else that limits your ability to do this in the redacted language, then we should know about it.
I redacted it. I'm not sure Marty would remember it. I'm not sure I exactly remember. I may have to, if we are coming back, I may have to clarify that for you. There were things in here that I thought were landlord and tenant issues and didn't affect the township, but I could double check that for you, because I can't remember exactly.
Okay.
And Mr. Ryan, with regard to the season, it is defined in C to be April 1 through September 30, which was the term that is in the ordinance for outdoor dining.
That's understood. That's okay by the board. That's.
Yep.
You can sit down, Marty. I'd just like to give some opening remarks, and then I was planning to call Matt Bauman and then Marty Grims back to the stand. I don't think we have a lot of testimony. I think this case is mostly a legal question, but for the record, I'm George Brosman. I'm representing Lucky Dog Enterprises, LLC, which does lease the space, as we've confirmed, at 200 West Lancaster Avenue in Wayne. As you noted, it is in the Wayne Business Overlay District, which was adopted in 2007 by the Township. My client operates the White Dog Cafe restaurant there, and we're here this evening on an appeal. The White Dog Cafe had requested a permit for an accessory outdoor dining area use on a patio that is located adjacent to the White Dog Cafe indoor space between the building that the White Dog Cafe is located in and Lancaster Avenue. It's an existing patio that's there where the outdoor dining would be. It's a request for 50 seats, and the application had certain time limitations in it. Essentially, it would be used in the evenings on the weeknights and in the daytime and evening on the weekends, but not in excess of the hours allowed in the WBOD, Wayne Business Overlay District Ordinance. The zoning officer had denied this application solely on the grounds that he believed that Code Section 280-5312B5, which is part of the general parking requirements for the Wayne Business Overlay District, that provision applied to outdoor dining and would require that there be additional parking for these accessory seasonal outdoor seats. We appealed that determination, and as you said, we had filed an alternative request for a variance. For the record, I will submit, as I indicated previously, A1, which is the application I filed, and A2, which is the letter that I withdrew the variance. Do the board members want extra copies of these, or should I just give to the solicitor, the chairman, and Mr. Rice?
Why don't you give them, if you have enough, give them to everybody.
I have enough. And Mr. Sheehan, I have one for you. That's A1, the application. A2 is a May 16, 2011 letter that I sent to Mr. Ryan withdrawing the variance request. I don't have a letter, but when the notice was read in this application, we had also talked about a vested right or a variance by estoppel. I'm not proceeding with those theories either on this application, so I'm strictly proceeding on the appeal of the determination as to whether the parking is required.
Would you then withdraw on the vested rights or variance by estoppel without prejudice to, pursue it in another application then?
Yes, that's right. I would withdraw those without prejudice at this time. This case, as I said, is essentially legal issues. I think outdoor dining, at least in my view, has proven to be a nice amenity in Wayne. And we have a nice spot here on the property, this nice patio to do it. And the ordinance has a lot of controls in it that limit it. It's just a seasonal thing. It's only allowed to operate under certain hours, and there's a lot of restrictions. On top of that, the application we filed limited the hours even more than is in the ordinance. I believe under the ordinance, you're allowed to go from 11 a.m. to 10 p.m. and at any day of the week, and our application was for 5:30 p.m. to 10 p.m. on the weekdays, and then the ordinance default of 11 a.m. to 10 p.m. on Saturdays and Sundays. So I think it's a good ordinance. It's something that encourages the outdoor dining. It's viewed to be as an accessory use, and we think that outdoor dining would be good here. As Mr. Ryan said, we did submit a legal memorandum where we spell out our legal theories as to why we believe the parking isn't required. Before I go into that at great length, I know you'll read the briefs, or maybe you have already, but basically in a nutshell, we believe the code, if you read it, you can see that the outdoor dining is not required there. There's a specific section on outdoor dining. It has a lot of standards in it, and it doesn't have parking in it. And there's a provision as you get near the end of the outdoor dining that says the zoning officer is to review the applications when they come in, and he shall issue a permit, it says, if the standards are met. So in this case, we believe all the standards are met. There's a process that's usually followed with these, that once the application comes in, it goes to the Township Design Review Board, and they look at some of the technical matters, and then the zoning officer, and I believe it's the health officer, look at some of the other requirements in the ordinance. So it's our position that he has, the zoning officer has discretion to only deny a permit if some of the outdoor dining standards are not met. the standard, and the reason that he denied the application in this case was because he believed it needed to comply with the parking, which is found in another part of the WBOD ordinance. And in my brief, I went into just some reading of the ordinance of why, even looking beyond that, if you look up in the other sections of the ordinance that authorizes the use, you can see that it's classified as an accessory use, and other accessory uses allowed in the WBOD, which are mainly just home occupations and outdoor dining under the specific provisions for the accessory use. For the outdoor dining, it sends you right to the outdoor dining provisions that I talked about and said follow these. For home occupation, it sends you to standards for that. And in the case of a traffic home occupation, it tells you that you need extra parking for a traffic home occupation. It doesn't tell you that for outdoor dining. I also cited in the brief a case, the Mitchell case out of the Commonwealth Court, that supports that idea that unless an ordinance specifically says there should be parking for an accessory use, that there shouldn't be parking required for an accessory use. So we have the specific accessory use standards for the outdoor dining, and they don't require parking. After this issue came up, we looked into some of the history of the ordinance, and I found the legislative history of the ordinance. And I found that an earlier draft of the ordinance showed that, yes, indeed, they had at one time said outdoor dining should comply with this parking section up above, very similar to what the zoning officer is saying today. But then in a later draft, the one that got adopted, that provision was specifically stricken out and deleted. So I think the cases say that if you would have any doubt about whether the parking is required or not, we think it's pretty clear that it isn't. But if you would, you could look to legislative history to see, well, what was the intent here?
Excuse me, George. Do you have anything that evidences the intent of the deletion? In other words, it could have been taken out for the reason you say, or it could have been taken out because they felt it was already adequately covered in other provisions. Do you have something that goes to the intent of the removal, or are you just inferring the intent?
No, we're inferring the intent from the fact that it was specifically put in there and it was specifically removed. And the Rossiter case that I cited in my brief, which wasn't a zoning case, but it was very similar. The Supreme Court basically said, hey, this was in here and it was stricken out. The intention is manifest, I think is what they said. And they said, we don't know why they did it, but it was in and they took it out, so we take that to be a manifest of the intent. But before you even get to the intent, there's a special rule of interpretation for zoning ordinances that it's called the strict construction rule, that in Pennsylvania, zoning has been recognized to be in derogation of common law property rights, and the rules and the cases have said that you have to strictly construe a zoning ordinance. So if it doesn't say that parking is needed, you shouldn't really interpret it that, oh, we're going to say this section over here applies. You should construe it strictly to give the benefit of the doubt to the landowner. But we have more than that here. Then we have the legislative history, and we also have a fairly long administrative history dating back to 2007. You know that you see a lot of outdoor dining in the Wayne Business Overlay District. We have looked into it and believe that they were all approved without requiring the parking, additional parking. So that is another guide, I think, as to what the intent was, that how it's been interpreted for a long time. And nobody, the commissioners didn't come along and say, hey, wait a minute, you're interpreting this in a way we didn't intend all these years, we're going to change this.
I have to just say, you're inferring stuff from your research, but I think we need to have some hard testimony
Sure, I'm gonna,
some quarter.
Yeah, I'm going to put in, I'm going to have Matt confirm that these are the documents. So I'll move on.
I guess, and the other thing, I do agree that where there's genuine ambiguity in the zoning, in a zoning ordinance, the cases talk about, do say that genuine ambiguities are reserved are resolved in favor of the landowner. But there's some other canons of construction that we need to keep in mind as well. That zoning ordinances are construed as a whole with effort to be made to give effect to all of the component parts, that you're not just supposed to focus on one provision and view it alone in a vacuum without that zoning ordinances are to be construed to be constitutional where possible. But I think there's an overall package of construction principles in addition to the genuine ambiguity principle that are at work here and would have actually come into play as in terms of determining whether there is an ambiguity. Let me ask you, to the extent if an ordinance appears clear, what case law in the zoning field could you point to that says you should still look at legislative history? If you were to find the ordinance clear or clearly ambiguous, take both. Should we be looking at legislative history in either event?
Well, if you found it clearly ambiguous, I think we would be entitled to a decision. I believe the cases say if you find it to be clear either way, you don't need to consult with, you don't need to look to what the intent was. This case is sort of tricky in that regard because I don't know how you could say it was clear the way the zoning officer is now saying it when it's been interpreted for everybody else this other way, and now it's changed. And also, we do have that history where we saw it was, in and then it was out, and and just the things I said about the ordinance itself, where it says in the outdoor dining provisions that he must review these provisions and he shall issue the permit. I would really be hard pressed to see how you could say it is definitely clear that the zoning officer is right here.
The other thing, we'll need some, I assume we'll get to some testimony on that, but my advice to the board, and please correct me if I'm wrong, I'm unaware of this question ever having come to this board before. I believe the case law does accord a zoning board deference in interpreting its ordinance, and while you cite a case which says that a zoning board may look at courses of enforcement, I've not read that case, but your quotation does not suggest that the zoning board is required to take that into account. I mean, it seems to me that this is before this board as a matter of first impression, and what people may or may not have done, whether that's relevant to a resolution, I think is de novo for this board to decide.
Yeah, I think under the Statutory Construction Act, which the cases say that it's not applicable to ordinances, but the principles are, so it sort of sounds to me like it is applicable. It says in the Statutory Construction Act that factors to be considered, and there's a whole list, legislative history and administrative history, so I don't think you could just ignore it. You would have to decide, I guess, what weight you would give to it, as well as the other things if you didn't find that it was ambiguous and you had to go into that next level of analysis.
Because, to be frank, it is perfectly acceptable, as my understanding, for zoning authorities, including a zoning board, to make changes over past policies in addressing an issue based on reconsideration, further developments in the law, just because, and that again goes to the very long-standing principle and very firm principle that a decision by a zoning board in one case is not binding precedent in any fashion for zoning board's consideration of another case.
Right.
Obviously, boards try to be consistent, but frankly, changes can be made.
Yeah, I think in this case, in my mind, there's so many factors. That's just one factor. All the arrows seem to me to point that, we're correct on this. That the ordinance doesn't require the parking for it. So you'll look at all of that in totality. You know, you'll look at my argument on the ordinance. I think it's clear that it's not allowed. I think if you don't say it's clear, I think you'll be hard-pressed to say it's not ambiguous. But if you even get beyond that, then we have the legislative history to look at, and we have the administrative interpretation. So there's all of these factors that really point toward that, you know, this should be permitted the way that it has been, and that the ordinance does not require the additional parking for the outdoor dining. So I think you understand my argument. I want to belabor it. I was going to just briefly call Mr. Baumann, ask him to identify those documents. I had shared these with him and Mr. Rice previously in the last couple of weeks, and was going to ask him to identify those and just have Mr. Grims briefly to talk about his proposal.
Okay.
If you're,
George, would you like me to stay here?
Can
or
he
come up
stay
there?
here? Is there a way to?
I think that would be easier if
Did
the
you want
mics
to put
work.
you can put the documents up on the screen, George, if you'd like.
Or I could just, I don't know if putting them on the screen, anybody will read them.
Okay.
I can hand them out. I can put them up if the board likes, but
Or maybe the
would be-
folks at home would like to see them, actually.
I'm not sure you any position on him. Do you swear or affirm the testimony you're about to give to be the truth, whole truth, nothing but
I do.
the truth? And faithfully, correctly?
Matt Baumann, Baumann.
Matt, you're the Director of Community Development and the Zoning Officer for Radnor Township.
Correct.
And how long have you had that title?
2 years now.
And prior to assuming your current position, what other positions have you held with Radnor Township?
Well, I was hired as the planner and the GIS manager, the mapping system manager, in January of 2005.
And did you receive the outdoor dining permit application for the White Dog Cafe?
Yes.
And you denied that application, that's correct?
Correct.
And your denial letter, which is attached to my Exhibit A1, that stated you rejected the application because you believed that Code Section 280-5312B5 requires additional parking for the outdoor dining area?
Correct.
And I want to turn the focus now to the Wayne Business Overlay District. Is outdoor dining at this location in the Wayne Business Overlay District governed by the applicable provisions of the Wayne Business Overlay District Ordinance, which was adopted by the Township Commissioners on July 16, 2007?
Correct.
And are the Wayne Business Overlay District provisions codified in Article, I guess it's 12A of Chapter 280, which is zoning of the Radnor Township Code?
Yes.
And so the Wayne Business Overlay District provisions are found in the code book at 280-53-2 through 280-53-17, is that correct?
Yes.
Since they were adopted in July of 2007, have there been any changes to the regulations with regard to or affecting outdoor dining?
No, there have not.
And I may have this wrong, but to my knowledge, the only amendment to the WBOD ordinance was regarding drive-through for prescription items.
Correct. That was for the Rite Aid application.
And so other than that, there have been no changes to those provisions since they were adopted.
That's right.
Now, you worked as the township land planner when the Wayne Business Overlay District provisions were first brought up for consideration and ultimately adopted?
Yes.
And were you involved in that process?
Yes, I was.
And after you issued your denial of the outdoor dining permit, I had met with you and Mr. Rice and provided you with copies of certain public records that I had obtained from Delaware County Planning Commission and Radnor Township. Do you recall that?
I do.
And that meeting occurred obviously after you had denied the outdoor dining permit, correct?
Yes.
And prior to making your determination, you had not had the benefit of those records?
The benefit in terms of reviewing them?
Right.
Correct.
Not since at least
Not since it-
2007.
Not since it was adopted
Right, in 2007.
in 2007, correct?
Now, I'm just going to go through for the record all those documents that I had presented to you and Mr. Rice, so I'll try to move through it as quickly as I can. I'm first going to show you what I've marked as Exhibit A3.
Pull that out.
Thank you.
A3 is a couple of documents put together. On the top, is that a letter that you had sent to the Delaware County Planning Commission?
That's correct.
And that letter was accompanied by a draft of the Wayne Business Overlay District Ordinance provisions that had been prepared and that was under consideration by Radnor Township.
Yes.
And attached behind the letter, I didn't mark it separately, but is that there was a review letter, and then is that the ordinance provisions?
Yes.
And then I'm going to hand you Exhibit A4.
If I may just interrupt, Mr. Baumann, A3, somebody handwrote 3/15/07. Did you send this letter on or about March 15, 2007?
I noticed that. Yes, I did, because there's a date inside the letter itself.
Yeah, it's Monday, March 12, so that would have happened by then. But it's March of 2007.
It was.
I see a Delaware County Planning Commission, the next page talks about the meeting on the 15th.
And I handed you up Exhibit A4. After you sent the ordinance in A3 out to the Delaware County Planning Commission, was there a hearing held? I believe it was on March 12, 2007, with the commissioners,
That's correct.
and they reviewed that version of the ordinance.
They did.
And what I handed you is A4. Is that the version of the ordinance that was reviewed at that hearing?
From my understanding, it is.
And in fact,
I'm sorry, the date of this hearing was March?
if you look at the last page, Mr. Baumann, or not the last page, appended to the back is a copy of a portion of a transcript from the hearing. It says it was March 12, 2007. Do you see that? It's a few pages from the back.
I see the last page, George. It says 6, page 6.
If you go 6 pages back from that is the cover of that transcript.
Thank you.
That's the cover that gives the date of March
That's correct.
12.
No, March 12, 2007.
And I attached the rest of this just because it's the relevant pages that identified this document. As you see on A4, there's a handwritten T7 on the top.
Yes.
T would usually stand for Township.
Yes.
So this is T7. That was the exhibit that was put into that first hearing.
Yes.
Now, focusing on this draft, T7, there's a table of contents. Do you see that on the second page?
Yes.
Section 15, outdoor dining. Do you see that?
Yes.
And could you turn to page 10? That's the beginning of the outdoor dining standards. Are you with me?
I don't have a page 10 in this document, George. It ends at 9, and then the transcript begins.
You must have gotten a faulty copy. Let me give you this one. Sorry about that.
That's okay. Thank you.
Is anybody else missing a page? Oh, I didn't give you that. I'm sorry, Mr. Sheehan. So do you have page 10 now, Matt?
I do.
And can you go to the section 10 is the beginning. Can you find this section? I believe it's 8.
Okay, I see it.
And is that the one? Yeah, could you read that?
Number 8, parking requirements for additional outdoor dining seats shall adhere to the provisions set forth in section 11.
And then could you turn back to section 11, which I believe is on page 8?
Okay, I'm there.
And do you see section 11 there? Do you see the B, the parking standards?
Yes.
Are they the same parking standards as they are today for restaurants?
Yes, they are.
Mr. Roseman, I'm actually a little bit at a loss. It looks to me like the draft of Chapter 280 attached to A3 is exactly the same as the draft of Chapter 280 that's attached to, that is Exhibit A4. Is there a difference here between these two documents?
The only difference is one was the one that was sent to the county and one was sent to the township, so I was just trying to give you all the
Okay, but
records.
these are the same.
They are the same.
Okay.
One was to the county and one was to the township. And then, now this draft of the ordinance was not adopted by the Township Board of Commissioners, was it?
No, it was not.
And in fact, changes were made to that draft. Is that correct?
That's correct.
And I'm going to hand out A5 and A6 together because it's like the last iteration. It's one from the County Planning Commission, one from the Township Records. So Matt, I've handed you A5 and A6. Looking at A5 first, that has a May 24 letter. Is that a letter you wrote to the Delaware County Planning Commission?
Yes.
And so what were you doing with this letter in terms of the Wayne Business Overlay District?
I was letting the county know that the township will conduct a public hearing on Monday, June 18, 2007.
And why would you have sent this to the county when you sent it previously? Is because there were changes?
That's correct. Any changes have to go back to the county.
And then in A6, is this the, strike that. Back to A5, that letter indicates there would be a hearing held on June 18, 2007 by
Yes.
by the commissioners?
Yes.
And then A6, and it has the relevant transcript page attached again. Is this the version of the ordinance that was presented at that June hearing in front of the commissioners?
Yes.
And on the cover of June 6, it's got a legend, if you will, under the word zoning. It's got a line for add and brackets for delete. Do you see that? On the cover page of A6?
Yes, I see that.
And is it your understanding then that anything in brackets was deleted from
That's
the prior
correct.
draft? So turning to the table of contents then on this package, Exhibit A6, you see there's Section 15 is still outdoor dining at page 10.
Yes,
Do you have a page 10 in this one?
I do.
And could you page down a couple, strike that, this Section 15 on page 10, that's the outdoor dining standards? Is that correct?
Section 50, yes.
And then go to page 12, the Section 8 that we looked at in the last draft. Do you see that?
Okay.
And that is indicated there in brackets to be deleted.
Yes.
And is this the version of the ordinance that was ultimately adopted in July of 2007?
Yes, this is the version.
And in fact, so that version that appears in the books today, that section that referred to the parking was specifically deleted from this.
Correct.
Moving on to beyond the ordinances to other outdoor dining permits, and I know you've only been the zoning officer for a certain time, and there were other zoning officers before you, but are you generally familiar with the outdoor dining permits that have been issued since the enactment of Wayne Business Overlay District?
I am.
And you're aware that numerous other permits have been issued.
I am.
And in fact, have any of the previously approved outdoor dining permits required that additional parking be provided for the outdoor dining?
No.
And I have a package. I've marked as A7, and this, I believe, is I shared this with you and Mr. Rice when we met a while back. I'll hand it to you now. It's just copies of various items relating to outdoor dining that was approved at other locations. And I'm not going to make you go through this whole package, but just to ask, are these, I don't know that they're all of them, but are they outdoor dining approvals that had been issued by Radnor Township?
Looking at these, yes, they are.
And these particular ones, none of them were required to provide additional parking for the outdoor dining?
Correct.
That's all I have for Mr. Baumann.
Mr. Brosman, I've got multiple copies of, I think, the same document, September 14th, 2007, letter to Doug Pastor.
They're all the same, George.
4, 5.
Yeah, I have multiple copies of Matador.
Yeah, I've got elegance.
So they're all the same.
Yeah,
So
I've got a
you-
whole lot of pictures.
You each
copies.
have,
A separate
A
application.
separate
they
application.
have a separate, I apologize for that. I'll have to recollate them for you.
We got stacks instead of collated sets.
Yep.
Yes.
Yeah, mine are all to a Mr. Palagano for COSI 220.
And I have Zaxby's, which is
If we're going to clear up this record, A7 should include one of each, I assume.
Yes.
Of these documents, not
Well,
what's been marked.
Yeah.
everybody keep one of your packets and hand him the rest of them, so he'll have them all. Kept this one.
Actually, I would give them, let's give the copies
give them
back.
all back.
And
Yeah, let
maybe
them collate
somebody
them.
on his team can.
Okay, well,
collate.
here, I will give it back to you, George.
If you get me involved in collating, we'll be really.
Just shuffle the deck and deal them out.
Up,
And I won't hold you up,
if the collators want to go over to that.
Actually, Matt, there's a question I could ask you while we're waiting to get those things that you won't need the packets for. just going down the list from Mr. Brosman's brief where he lists these items. Johnny's Doghouse, Christopher's, Saxby's, Elegance, Great American Pub, certainly Bravo Pizza, and Matador. Are they all on streets where there's metered parking? So we have Luella Court. We have North Wayne Avenue.
They're all metered, correct?
Yes, they are all metered, yes. Okay, I just wanted to get that fact on the record. I think that might become important at some point.
Let me just, as a follow-up, are the restaurants that are, for which these permits have been issued, are they sites which simply do not, because of existing nonconformities, provide any on-site parking? I guess maybe the question
I'm going
is
to
why...
say most of them do, John. I think some of them may have a few spaces in the rear. For example, Bravo Pizza, I think, has 2 or 3 allocated in the back, correct? 3 in the back for Bravo Pizza. But as a general rule, though, most of them do not have any off-street parking.
Why the difference in enforcement, then, as to the White Dog Cafe versus these establishments?
That's a very good question, and the solicitor and I have discussed that. I'm going to say that it was past practice, not policy, but practice, to issue these outdoor dining license applications regardless of whether there was indoor or outdoor seats, okay? So I inherited that practice and continued it for one more application until the solicitor and I had a conversation, and that's when we halted this.
Well, you know, this might help clarify it. At 28513, I'm sorry, 53.12, there's a sub A and a sub B, and sub A deals with the cases where there's on-street parking, and sub B deals with cases where there is no available on-street parking. And the requirement of so many spaces per seat applies only where there's no on-street parking available. That's why I think it may become relevant to our discussion.
And I think also, Noah, that the reason for A, from my recollection is from 4 years ago, is to write that in there is to make sure that, so we don't own that land in front. Those are all easements for those parking meters, and if those were ever to, those easements were, if they vacate, whatever the language may be, that the township wanted to make sure that we always secure those metered spaces to benefit the public coming to Wayne, that those didn't disappear.
I would like to just, I will comment that when I first began service to this board as solicitor in January of 2000, it was common practice in the center of Wayne to, for properties that had no parking or very little, to grant relief from the parking requirement by special exception, and that this board, on reflection, decided that the more appropriate way to treat that was by variance, with some acknowledgement that a property that has no parking has to be allowed to have uses, reasonable numbers of uses, but maybe not the most parking intensive use, but they had to have adequate uses based on their nonconformance. But it was no longer a straight special exception, and I do know that this board changed that about 10 years ago in terms of how it approached that situation. But your testimony, Mr. Baumann, is that you inherited this practice, you issued one more such permit, and then based on advice from your solicitor, you have is it a fair thing to say that you have adopted a new policy in that regard?
That's correct.
Mr. Baumann, was there any, in connection with the prior practice, was there any consideration, or did you make a determination about the compliance with respect to the number of parking spaces? Was that analysis ever done?
For outdoor dining?
Yeah.
No, there was never an analysis done for outdoor dining. It's seats. So, for example, if 24 seats were put outside, technically by the code, in our opinion, that it would need 8 parking spaces, but that analysis was never done.
Okay, but for example, I think Bravo Pizza has 4 seats outside.
Correct.
So you don't know whether or not that those 4 put them over in terms of the number of parking spaces they need.
No, I don't know that for certain, but if I were to take a guess, I certainly would think that it would.
Okay, thank you. Mr. Brosman?
That's all I have for Mr. Baumann at the moment.
Okay. Any other questions from the board for Mr. Baumann?
Actually, did we cut you off, Mr. Rice, in terms of questions you wanted to ask?
Well, I may have one or two questions for Mr. Baumann, but a couple of them had to do with A7, which I think has to be marked. And I'd like to ask him about some of those prior. I mean, I can do it now, or I can do it when Mr. Brosman's done with all his direct examination or his case in chief. I can recall Mr. Baumann at that time.
Would it be? It sounds to me it might be easier if we all had the correct exhibit in front of us while you were doing that questioning. Does that?
Yeah,
make sense?
I would like to do that. Why don't I suggest this, because I don't have a whole lot of questions for Mr. Baumann, but I would like to ask him about those prior approvals, have them all in front of me with properly marked exhibit. If Mr. Brosman is done with Mr. Baumann, then I would just suggest we move on to their next witness, and I'll just bring Mr. Baumann back when
Okay.
we're
Let's
ready
do that.
for him.
Makes sense. Is that the
Here we are.
A7s now?
Do you need a minute, John, to look through A7?
Yes, please.
Okay.
Do we want to take a 5-minute?
Yeah, let's take a 5-minute recess.
I've seen you biking on State Street.
Ladies and gentlemen, we're back on the zoning hearing board. Mr. Brosman, did you have anything else? Okay.
Mr. Chairman, if I could just ask
Sure.
one thing in clarification. We've heard testimony, we may hear more, that there's been a change of enforcement of how this ordinance is enforced by the township, that the permits previously were granted by Mr. Bauman's predecessor, that he granted one such permit himself, and then after consultation with the township solicitor, agreed that the outdoor dining seats required parking. As I understand your present petition, with the withdrawal without prejudice of the vested rights variance by estoppel argument, that change of policy is really to be considered by the board as just considering how it's been applied in the past, but not at the level of entitling you to a variance by estoppel or a vested right, because you've removed that from your application without prejudice to refile at a later date. Is that a fair statement?
Yeah, that's what I had done initially. I'm not sure, after hearing the testimony, whether I want to stay with that. I may want to reinstate that and keep that alive.
I think we need to know that, because I have some questions I may want to ask if that's
Okay.
not the case. So we can only hear the case you put before us. Is it in there or is it out?
I know,
George?
I just heard
You've
the
got to make up your
testimony.
mind.
I had, and then I heard the testimony, so I guess with leave of the board, I'll leave that in.
So you wish to restore that claim,
Yes.
the vested rights, and
In that case, I have some further questions for Mr. Bauman. Yeah.
I think we
need-
can do that because it's all the same hearing. I don't think we have to, we do not have to re-advertise, in my view, for something we agreed to an hour ago, but I guess we better be clear with what's in.
Okay. So the
Okay, then I'd like to ask Mr. Bauman a few things. Matt, do you have the code in front of you?
I do.
In Section 280, 53.12, could you read into the record subsection A, on-street parking?
On-street parking. Where on-street metered parking currently exists, parking shall remain on-street to the maximum extent possible.
And subsection B, the initial part of that, the initial paragraph?
Off-street parking. Where off-street parking is provided, parking spaces shall be located in the rear, side, or underneath of the building and comply with the following requirements.
And that issue here is B sub 5 for restaurant. I guess we should read that in.
Yes, restaurant. Number 5, 1 space per 3 seating accommodations plus 1 space per 2 employees on the greatest shift on the shift of greatest deployment. Excuse me.
Now, as we mentioned before, but now looking at this particular property, is there metered parking available on the street front of this property?
No, there's not.
Okay. Now, if we look at section that defines the use regulations, 280, 53.7, I see an F, if I'm correct, sub F, it talks about accessory uses on the same lot incidental to the foregoing permitted uses, right?
Yes.
That's what it says?
Yes.
Okay, so A through E are the permitted uses. They're principal uses, right?
Yes.
And could you read into the record A, the top of A, and then A3, dealing with restaurants?
Retail uses shall be limited to the following.
Okay.
And then 3, restaurant or catering establishment, including outdoor dining.
So outdoor dining is actually part of the principal use when we're talking about a restaurant or catering establishment. Isn't that what the code says? Isn't that how you'd interpret it?
That's
I'm going
correct.
to object.
Well, I'm trying to get into the record of the text we have to interpret to handle your
But
application.
I'm going to object. You're supposed to be hearing our case as a fair and impartial.
No, we're also inquisitors. We have to get to the facts and decide how to apply the
Could I
the law.
finish? You're supposed to be hearing the case fairly and impartially, and you're presenting a line of questioning with all due respect. I mean no disrespect by it, that you're making a case out, it sounds like, contrary to my client, and we expect you to be the fair
No,
and
I'm
impartial
trying to
judge.
get on the record the provisions of the code and the interpretation of the zoning officer dealing with the case you are now advancing,
But
which
that's-
is you're claiming that you're entitled to a vested right variance, and you're also asking for an appeal, an overturning of his decision as a zoning officer.
But that's
So
not your
that puts
role.
into record, I'm not allowed to ask questions of witness.
You can ask some questions, but it seems like you're prosecuting the case against my client's position.
Mr. Brosman, Mr. Cutler has raised something, and he first brought it to my attention, and I'm concerned about it too. I see two pieces of this case. One is which is where we were until we came back from the recess, a pure legal one. What does this code say? How does this code to be interpreted? And that means we have to look at the code sections, decide if under canons of construction and so forth, whether the code says you're right or the township is right. I think the vested rights being back in play, we have to get some factual information on what the township has done and whether that gives rise to some sort of a vested right or variance by estoppel. But frankly, to me, the legal case, you get to variance by estoppel and vested rights if the law is the wrong way. But it's relevant to what does this ordinance require, and whether it's done through a line of questioning by Mr. Cutler or being subsequently addressed in your testimony or your legal argument or maybe a supplemental memo. I'm worried about those questions in terms of how does this ordinance get interpreted? What does this ordinance require? And to me, the dichotomy between, it seems to me, for example, that a bakery and an ice cream shop in 53.7A1 are being treated differently from a restaurant, that you could have outdoor dining as part of a bakery, for example. And is that a distinction that could have been made by eliminating the parking requirement in Section 16, I guess it was, a reference to this, and therefore by falling into a situation where perhaps you don't need to provide off-street parking for seating for an ice cream shop, but you do for a restaurant, and maybe there's a reason for that, a rational reason for that, maybe not. But to me, we're trying. The crux of this case is very much a legal question. The factual piece is, to be perfectly frank, unless something is developed that I haven't heard yet, and I'm just speaking for myself, it seems to me we're really heading down toward about as close to a purely legal case as comes before this board, unless facts develop differently.
Yeah, I think in this case that's probably right. I have the vested right only because what I heard was, there was a change in policy for no apparent reason, and I think that creates a potential vested right argument in that my client, and we'll have a little bit of testimony on this, relied on the long-standing policy, and when he rented the place, he'll testify that there was a patio there right next to his space.
Can I suggest I'm going to object. Mr. Brosman's been testifying most of the night, so I think we ought to move on to the next witness. If the board's done with the zoning officer, because it's not a solely legal issue at this point. Now we're talking about vested rights and variance by estoppel, and there are factual determinations that this board is going to have to make based on whatever Mr. Grims is going to testify to. So I'd like to hear him testify.
Did you want to talk to inquire from Mr. Baumann, or you want to hold him to the?
Yeah, I would defer with Mr. Baumann. I had some questions about Mr. Brosman's direct examination, but I have other additional testimony and exhibits I intend to put in through Mr. Baumann. So whenever we're done with Mr. Brosman's case in chief, then I'll be ready to call Mr. Baumann. I can do it all at once.
Okay.
I think, Mr. Brosman, you have to understand that we're going to take notice of what the code says, all of the sections. Now, we can either decide all that on our own, or I can lay the cards on the table and let you know the things in here that trouble us and that we have to focus on to decide this case. If you'd rather I keep my mouth shut and we'll just consider those among ourselves when we make our decision, I won't telegraph it. Then we'll take the code as it is. We read this code. We understand it. I was just trying to point out to you that there's a distinction made in this code, and I wanted it to get on the record, between a restaurant and catering use, which is a principal use, seems to include outdoor dining as a contemplated part of the principal use, versus every other thing that's listed here as principal use, where outdoor dining would be an accessory use. Your whole argument seemed to rest on the fact that accessory uses are treated differently. I don't know if we buy that or not, we'll decide that. But the point is, you have to understand that in this case, we're not talking about an accessory use. Your client runs a restaurant, I can tell from his testimony and from reading your application. So therefore, outdoor dining is part of his principal use, and the seating would be no different whether it's indoors or outdoors as far as parking requirement under the other section we talked about, 53.12. So that was the point. If you thought I was opposing you, I'm sorry. I didn't mean to take on hostility. I was just trying to get to the facts quickly.
I have no
I'd
no
like to see
problem
the
with
end
you.
of the Phillies game if possible.
No problem with you sharing your concerns on the legal theory with me.
Okay.
We can leave it at that.
Okay, your next witness?
Marty Grims. He's still under oath. We don't need to re-swear him. Marty, is White Dog Cafe a licensed food establishment by Radnor Township?
It is.
Mr. Grims, you're going to need to speak into the microphone.
It is.
Do we no longer have the
And for the record, I was up to Exhibit A7 with Mr. Bauman, but we had put in A8 in the beginning, which was the lease.
Yep.
A9. And you have a certificate of occupancy from Radnor Township?
We do.
And I'm showing you A9 and A10. Is A9 your certificate of occupancy?
It is.
And is A10 the food license for White Dog Cafe?
It is.
And it lists you as a food establishment?
Correct.
And was an application for a 50-seat accessory outdoor dining area filed with Radnor Township?
It was.
And are you generally familiar with 28053.16, outdoor dining provisions of the code?
I am.
And are you requesting any variances from any of those provisions for outdoor dining?
I am not.
And prior to leasing the space, was the patio there outside of the space that you rented?
It was.
And were you aware that other outdoor dining had been allowed in the Wayne Business Overlay District without requiring additional parking?
I was.
And what was your plan with regard to the patio area?
The outdoor patio was an essential part to our business plan, anticipating the use of it during the spring, summer, and early fall months.
And had you, in fact, purchased the outdoor furniture?
We had.
Sorry, when was the outdoor furniture purchased?
It was purchased along with the other furniture for the restaurant.
And when was this?
The restaurant opened in November, so I had a designer who actually did all of the actual purchasing. We spent approximately $100,000 on the outside furniture for the restaurant.
And this was back in November?
Prior to November. The restaurant opened in November.
Was that before or after you applied for an outdoor dining permit?
That was before.
Okay.
That's all I have for Mr. Grimm's.
I have some questions for Mr. Grimm. Mr. Grimm, how many seats do you have presently in your restaurant?
118?
And what's the total parking that's available on this property, on this parking lot?
I believe 158 spots.
158, okay. Now, how many are you going to add in the outdoor dining?
50.
So how many would be required if the ordinance applied to all of it? Has anybody done the calculations? To meet the requirement of the ordinance section, do we know how many spaces he would need?
Core says it's 16.
Hmm?
Core says it's 16 spots.
16 and a half.
That's for
It would be 56, 3 into 1.
one space per 3 seating accommodations,
What, it'd be
plus
fif-
one per 2 employees, and the shift having the greatest employment.
56 spaces would be needed, Noah, and then you would have to count in the employees.
56 plus employees. And what would be an estimate of the greatest number of employees and the biggest shift?
Our greatest estimate is 20 employees.
Okay.
Is the property currently compliant, putting aside for the moment the patio, is the property currently compliant with respect to the number of parking spots available?
I probably know the answer better than Mr. Grimm's to that.
Okay, that's fine. I'll direct my question to you then.
And I'm not under oath, so Mr. Baumann should probably confirm this.
okay. Matt, do you know whether the property is currently conforming with respect to the number of parking spaces, assuming that the patio is not in use?
At 118 seats and 20 employees, this business it conforms with our parking code.
Okay, and if the 50 seats were added, how many would they be over, if at all? Do you know?
Assuming they don't add any employees for this 50, because that's a question I would
Yeah,
need to
that is
understand is better.
Would you add, we'll ask the question to Mr. Grimm's then, would you add employees if you had additional seating on the patio?
The outdoor dining would require 3 servers.
Okay,
So the question here is, we'd probably distribute the servers, some of the servers that were outside as well,
so it's a net increase of 3.
at maximum.
Yeah,
Well, that'd be 2 spaces for 3 employees.
right, so 2 plus,
So it would be 68 that would be needed.
I'm not sure if I'm clear. Are you saying you would be increasing over the 20, or you're just saying how many?
No, I'm saying that it would require 3 employees to take care of the guests on the patio.
so would you increase the number of employees on a shift?
Within our 20 employees, that would cover it.
Okay.
That would be the maximum.
So even
Number
if you have the outdoor
50
dining.
extra
it's
places with
20.
no additional servers.
3 additional servers would be required. But what we're saying here is the maximum number of employees for the greatest shift of employment would be 20 servers, 20 people, which that's in our
Counting
in our counting now.
So
you'd have
so we need
50 more
17 additional
diners and-
spots.
50 more diners and no additional servers?
No, it would require 3 additional servers. A station would probably, be 15 to 17 seats per employee.
Right now, the maximum number of employees is 20 for all the indoor dining.
Correct.
So if you added 50 people outside, that would be 3 additional servers, that would be 23 employees, correct?
But what we would do is we would distribute the employees differently to include outside.
So there would be no increase in the number of employees. It would
That's the
stay-
same map they use
That's
in
what I'm
the
saying,
federal
you'd add
budget.
50 new diners with no additional service
Okay.
from existing employees.
Okay, so it's at least 17 additional spaces. Okay.
And we're talking about-
And is there capacity on that lot? Are there 17 free spots available?
Well, that's what I was going to get to. You're talking about 5:30 p.m. to 10 p.m. Monday through Friday, 11 a.m. to 10 p.m. Saturday and Sunday, right? Now, there are other tenants on the property, and there are retail tenants, things like that, right?
Right, I
Have
fear
they
that
all
we've
given up their
hijacked
rights?
Mr. Brosman's case because I think he's going to put this in. Have we hijacked your case a bit?
No, I was going to say, though, I'm not seeing the relevance of this.
Are all those spaces available? In other words,
Our case-
Will the store next door be open during these hours? Do they require parking? Have they relinquished their
I
rights
mean,
to park at night?
We're not asking for variance, so our case is, it doesn't matter. We don't need extra parking for the outdoor dining. That's what our case is.
You're
Okay,
saying
that's
that
fine.
Matt Bauman wrongfully denied your permit on the grounds you didn't have sufficient parking. So it's not relevant whether there's sufficient parking? Is that what you're telling me?
No, he didn't deny our application whether there was sufficient parking. He denied our application. He doesn't make an analysis on any case, is there enough or not enough. He looks at the code and says, does the code require more parking? So he said the code section 280-5312B5 applies to our application, and we must provide that many more parking spaces for the number of new seats.
Matt,
we
did you
appealed
deny
that.
them based upon insufficient parking, or what was your reason?
I did. We issued a certificate of occupancy on March 2nd for 118 seats and 20 employees, and that's it. And had they had more parking, they would have gone to more seats, but
So
that's
he is
that's the
denying
park-
on that ground, so
So
it's
they-
relevant to the appeal.
It's not. I mean, he's saying, he says it in the letter that's A1, that this section applies. We say it doesn't apply. So if it doesn't apply, it doesn't matter.
Okay.
Well,
If
if we
there's
buy
any-
your
He's-
interpretation of the
he-
ordinance, but
he's-
maybe we don't.
But his point is he's limiting himself to a legal argument and/or a vested rights argument, and he doesn't even want to go there.
If-
He doesn't want to use that alternative relief, so that's
If
up
you
to
don't
him.
buy my argument, I lose.
Okay. Good. That makes the case much quicker.
Okay, sorry, go ahead.
That's all I had for Mr. Grims at this time.
Okay. Anyone on the board have any questions for Mr. Grims? Any further questions? Mr. Rice, any questions for Mr. Grims?
A few. Mr. Grims, do you have Exhibit A8, the lease, in front of you? If you could take a look at that for me, please.
Okay?
Okay. The first 3 pages to Exhibit A8 is called the Fourth Amendment to Agreement of Lease, correct?
Correct.
And the date is May 1st, 2011, right?
That's correct.
So it's just been signed in the last 19 days.
Correct.
Okay. Now, this is the authorization you have from the owner of the property, Wayne Town Center LP, to use the outdoor patio for outdoor dining, right?
Correct.
And then, as I go through these attachments to the Fourth Amendment, I find there's a Third Amendment, and a Second Amendment, and a First Amendment, and all of those you've signed, right?
Correct.
And they deal with the other parts of the restaurant, the indoor dining parts, and not the outdoor dining parts, correct?
That's correct.
Okay, so none of those other amendments make any mention of permission from the landowner to use the patio for outdoor dining until we get to the May 1st, 2011 amendment, right?
That's not correct.
Okay, where else in any of these leases is there a mention of outdoor dining and the use of the patio?
It was always understood when I was negotiating the agreement with Mr. Kelly that we were having outside dining, and henceforth we ordered the outdoor furniture. It was always understood. It was advertised to us that we had this beautiful outdoor terrace for outdoor dining.
But you didn't put it in any of the other amendments, is my point. It's not in writing in any of the other amendments. Not what you understood, but what was actually in writing. The written permission is not anywhere else until we get to the Fourth Amendment,
What is
correct?
the term of this lease? How many years?
I believe it's a 10-year term with 2 5-year options, I believe.
Well, under the statute of frauds, you can't have an oral lease for more than 3 years. So this amendment would have to have been in writing, and there was no legal right.
Well, actually, you can't. It's a defense to enforcement by the other party to the lease. Has to be pled.
Well,
It doesn't
but
make the lease invalid.
It's not, it
sorry.
doesn't become, it becomes, I guess, voidable, right? As opposed to void.
Well, I think in terms of a vested right, though, I think we can take notice as to whether this lease, whether there was a binding lease. I mean, that has to be pled and all of that, but in fact, there was could be pled by the landlord that there's not a binding lease on this point because it's a lease for 10 years.
But the landlord could come and testify that that was, in fact, the understanding, and that was, right.
You could come to testify to that, I suppose. Perhaps it's somebody you might want to bring in at some
I think what's important is that there was no authority for them to make this application or contemplate that they'd have that right until it was memorialized in the lease. I think that's as far as we can take that. But that's significant. It's important to know as a fact.
I just want to get Mr. Grimm to agree with me that other than this fourth amendment, there's nothing else in writing in any of the prior amendments, in writing, not what you understood, that you could use the patio for outdoor dining, correct?
That's correct.
Okay. Now, on the Fourth Amendment, I have a couple questions about the terms that are not redacted. The use, as it's stated, it says it's limited to 50 seats, and the season is defined as April 1st through September 30th, correct?
Correct.
But there's no hours of operation on this lease at all, correct?
No, I believe that there are hours of operation on the lease.
In your outdoor dining lease, tell me where the hours.
I believe they're probably redacted. Actually, on page, if you go to, I think it's part of the redacted part, George.
There's reference in the Third Amendment to hours of operation.
I was going to get to that next, but just in this, let's just stay on the Fourth Amendment. There's no hours in here, although your application is proposing what's been applied for is 5:30 p.m. to 10 p.m. Monday to Friday, and 11 a.m. to 10 p.m. on Saturday and Sunday for the outdoor dining, correct?
That's correct. I don't know if the hours of operation were redacted, so I'd have to see the original copy.
Okay. On the Third Amendment to the lease, if you can go to the fourth page of Exhibit A8, there are some hours of operation in there, lunch hours and dinner hours. Do those hours pertain to just the indoor dining that you currently have occurring?
Correct.
And you don't have any separate understanding with the property owner that you would follow those hours for outdoor dining, assuming you got some kind of an approval, right?
The understanding with the landlord is that we would have permission to use outdoor dining from, 10 o'clock to 11 a.m. to 10 p.m. on Saturday and Sunday, and weeknights from 5:15 or 5:30 till 10 o'clock.
Okay, and that's what you've applied for?
That's correct.
To the township, okay. You testified that the restaurant opened in November of 2010, correct?
That's correct.
And you also testified that you've spent $100,000 on the outdoor furniture. Did I hear that right?
That's correct.
Just on the outdoor furniture, $100,000.
That's correct.
Do you have any invoices or any proof of that with you tonight?
I have them, but not with me this evening.
And we're talking about how many tables outdoor?
Our original invoice probably had more tables than the 50 seats. We worked with the township. Originally, our original estimate included more tables and chairs, and then working with the township, we arrived at the 50 seats at a later time.
The 50 tables for
50 seats.
50 seats for the outdoor dining.
Correct.
And how did you work with the township to arrive at that number?
They looked at means of egress, given the fact that the patio at the present time only had one means of egress. In the code said we would not be able to exceed 50 seats.
So just so I'm clear whether we're talking about outdoor dining at this point, and your testimony is you've spent $100,000 on the 50 seats, which would be how many tables for outdoor dining?
No, we spent $100,000 on a number of seats and tables in excess of the 50 seats. Only recently have we come to the determination with the township that the township would limit us to 50 seats.
For outdoor dining?
Correct.
When you say you came to a determination with the township, who was that at the township?
Ray Daly.
That if you were going to be able to do outdoor dining and you got your approvals, this would be the limit?
Given the fact that we only had one means of egress.
Okay. And did you give him a layout of the patio area?
We did, and it was in the package submitted to Matt Bauman.
For the zoning hearing?
No, that would be for the design review board, correct?
That's correct.
Okay. Since November 2010, have you had any valet parking on site? And if so, what days and what hours has that been occurring?
We currently use valet parking Monday through Friday for the lunch hours from 11:30 till approximately 3 o'clock.
Okay. But not at the dinner hour Monday through Friday?
Not during the dinner hour. All of the offices are closed, and most of the tenants have closed as well.
Okay. So during the lunch hour, tell me, describe for the board how that is working with the valet parking.
I just object. I'm not sure of the relevance of this. We're not even proposing the outdoor seating at the times with the lunch hour when there is the valet parking. So
Well,
I'm not
when-
sure of the relevance of this to our application.
When Mr. Brosman reintroduced the vested right and the variance by estoppel, then that goes to good faith, that goes to expenditures, that goes to a lot of factual issues. And this board has the right to know what's going on out there at this time. If additional seats are going to be added, how's the valet parking working? Where are those cars going when the lot's full? That's all fair game.
I just don't see it.
Well, the board
We're
can
not
rule.
doing-
The board
well,
can
I'm
rule
ask-
on that.
Yeah, I mean, my response is that the valet doesn't occur when the outdoor dining is, so it's no relevance.
I guess, well, the question that if I'm following Mr. Rice correctly, these issues would go to, whether you would have perceived this use as a viable use, which is part of, I mean, there's no point getting a vested right in a use that you're not going to be able to do. That's kind of silly. So to the extent that can you do this use if it's granted? It's not just the townships allegedly through conduct or some such giving assurances, but is it assurances for something you could viably do? If Matt Bauman tells me that I can have an interstellar space pad on my residence, that I have no reason to rely on that because that doesn't exist yet.
Okay, I want to hear very, very little about valet parking. So the question was, can you tell us?
Well, my question is, during the lunch hour, Mr. Grimm, how does the valet parking work? How many people do you have parking other people's cars, and where are they parking them at?
We use valet parking Monday through Friday from approximately 11:30 a.m. to 3 p.m. Typically, we use 3 valet parkers. The front part of our parking lot, our space is reserved for the restaurant's use. So when customers come onto the lot, we take their cars and valet them on site. And if the spots are all used on site, then they valet park them off site.
And we're at off-site, specifically on the street?
Metered parking on West Wayne Avenue, on the lot across the street from the firehouse adjacent to the library, as well as on Bloomingdale Avenue.
Can you, might be able to see this. You can just point out for the zoning hearing board, we can put it on this table here. Maybe you can point out, so it's on the screen. We're going to have to put it over here, Mr. Grims. If you can point out, what I'd like to do is mark that aerial photo of the area as a Township Exhibit T1, and that's the only one I have. I'll provide copies to the board after tonight. And just, Mr. Grims, there's a big red circle there. Is that the building you're currently located in?
It is.
Okay. Now, if you could just describe when the lot is full during the lunch hour, where your valet parkers are parking these additional cars.
As I said before, we have spaces for the restaurant's use in this quadrant along this. I guess it's the eastern side of the property as well. Okay, and where West Wayne Avenue comes into. Do you see it marked here? I believe this is West Wayne Avenue?
Is West Wayne here?
Okay, so West Wayne Avenue, there are a bunch of 10-hour meters here. I believe that on Bloomingdale Avenue, I think this is Bloomingdale here, there are 2-hour time limits for people to park their cars. And I believe this is the other parking lot adjacent to the library in this area and the fire station, this parking lot here.
Okay, so when your valet parkers drive a block or a half a block or 2 blocks away, they park the car and then they walk back, they run back to the restaurant for the next car?
Correct.
Okay. And how are they getting back to your restaurant? Say if they're on West Wayne, are they cutting through other private property to get back? Do you know?
I don't know. But I do have to say that most of the parking, with the parking that's provided for the restaurant, that accommodates probably 90% of our customers at lunch.
During lunch? So,
correct.
But during the lunch hour, during the lunch hour, you're proposing to also have available these 50 additional seats if the outdoor dining gets approved, correct?
No, what we're proposing is seating during the dinner hour and during the weekend on Saturday and Sunday for use during the lunch hours. But during the weekends, we don't need valet parking because there's 158 spots on premise.
I'm talking about during the lunch hour. Right now, during the lunch hour is when you are utilizing the valet parking.
From Monday through Friday.
From Monday through Friday.
Correct.
So Monday through Friday, you'll only be doing outdoor dining for the dinner from 5:30 to 10. Is that right? Correct?
That's correct.
Okay. Have you had to use any valet parking for the dinner hour, either during the week or on the weekends?
No, there's an abundance of on-site parking.
Even on the weekends?
Even on the weekends, yes.
Until you submitted this recent application for outdoor dining, you've never received any kind of permits or approvals or anything in writing from Radnor Township authorizing you or telling you that outdoor dining was permitted on this site, correct?
No.
I've got a Exhibit A9 as a CO, Certificate of Occupancy, which you marked from Radnor. There's nothing on A9 that talks about outdoor dining, correct?
That's correct.
And on A10, which is the Board of Health license, there's nothing on there about outdoor dining, correct?
That's correct.
Mr. Grims, have you investigated any other lots, whether private or public lots, for your valet parking other than to park these cars on the streets?
We have.
And what have you found out?
We originally contacted, I believe the police department about the possibility of valet parking on the AT&T lot across the street. I was doing some research and seeing that on most days there was excess parking available on that lot, and that seemed to us the easiest and best alternative. And in exploring that, we were told that at the present time, the township decided that they did not want to allow anyone else to use that parking place. And we also contacted other property owners to see if their lots were available for valet parking.
For the lunch hour? Is that
Correct.
Okay. So the AT&T lot was unavailable or full for the lunch hour. Is that what you were told?
No, I was told that it had exceeded the number of permits that were issued.
Right.
We noticed that there was still availability for additional parking there, and we were also on a waiting list to get permits.
Did you look at all of the South Wayne lot?
The South Wayne lot is, which one's the South
I
Wayne?
believe on that, you might need to move that aerial photo. There we go. The bottom right-hand
Is
corner.
the South Wayne lot this one here?
Correct.
Okay.
Excuse me, John, where are we
Well,
going
it's
with this?
metered, so I believe that they are using that as well.
Okay. That's all I have
Okay.
with this witness.
Does anybody else, Mr. Bozeman, do you have any follow-up with Mr. Grims?
No.
Okay.
Not at
Anyone
this
on
time.
Okay. Anyone on the board have any further questions for Mr. Grims? Okay. Thank you, Mr. Grims.
Thank you.
Mr. Sheen, did you have any questions for Mr. Grims? Okay, why don't you come on up? Mr. Grims, I'm sorry.
Hi.
Hi.
Mr. Grims, do you recall that there was a notice posted on your employee entrance that had to do with where your employees should park their vehicles?
I do.
Mr. Sheen, if you don't
I'm gonna
mind.
object.
On what basis?
Relevance, again, I don't see the relevance of where his employees park to what our case is.
May I speak to that? Because I've
course.
researched this, yeah. The, under the code, the required parking has to be either on the property, in the rear side yard or under the building, or in metered spaces on the street that fronts the property. So it's relevant in determining whether you have adequate parking for any particular use to look at those spaces. And if you're making those spaces adequate by parking where you're not supposed to be parking for that use, I suppose it's something the board can consider. If he wants to put that on the record, we'll give it the weight it's entitled to.
But again, my case is we don't need to have any parking for the outdoor dining. So it's really not relevant. It was like the discussion we had before.
So you just
Mr.
want
Bozeman,
to...
though, you did bring back the vested rights. If it was purely a matter of, does this ordinance require parking for outdoor dining, and that was it, I would agree wholeheartedly. And that's why I asked the question to confirm that these other issues were off the table. But now that they're back in the case again, unfortunately, evidence relevant to that issue has to be, it seems to me, has to be allowed.
But I don't see, our argument on vested right is having to do with the fact that the patio was there, the prior interpretations. So we think there should be a right granted based on that. I don't see the relevance.
I'll give you an example. You tell us that now you do not need valet parking on the weekend because you have adequate parking because the other spaces in the building are being used lightly, if at all. And that makes sense. But what if it's only adequate because you are improperly parking on all kinds of side streets and other people's property? Then it would be relevant. So it's important to know where these cars are going, whether they're employee cars or patron cars, because it may be relevant. And do you want the facts in the record or don't you? Otherwise, we'll draw whatever inference we want to draw from
And I
it.
do believe for a variance based on estoppel, I do believe that adverse impact, like any other variance, is something that needs to be considered as part of the package. I personally regard the rules as different somewhat from a normal variance, although frankly, as you're well aware, there's some muddy language in some of the cases there. But I do think that to the extent that that if it were true that the only way this works is to park in places you're not supposed to park, then it seems to me that's still relevant, even if it's just for a variance based on estoppel.
Well, I think I'm pursuing the vested right more than the variance by estoppel, I guess, because the vested right is really what I'm talking about. Based on the decision, all the decisions that we had before for the other outdoor dining and the things that Mr. Grimm's talked about, maybe it shouldn't be characterized as a variance. It's a vested right.
Yeah, vested right only comes into play when there's a permit issued. There's no permit issued here, and there's reliance on the permit issued, whether it was issued in error or otherwise. That's the vested right cases. There's a whole, they go back to the mid-'70s. Petrosky is the seminal vested rights case. Different than a variance by estoppel when there isn't any permit issued. There's something else that the government's done, and in good faith is one of the elements in that. Bernie Enterprises versus Hilltown Township Zoning Hearing Board. It's a Commonwealth Court decision. That's your variance by estoppel case. It has all the elements in it. Two different arguments. I don't know which one Mr. Brosman wants, and the one I guess that fits what he wants to do now. But the vested rights doesn't come into play unless there's a permit issued. There's no permit here that's been issued, in error or otherwise. So,
Mr. Sheehan,
Yes.
I'll give you a couple of minutes on this.
Okay.
On this, but
Okay.
let's don't belabor it because, frankly,
I'm not going to do that.
I have serious reservations about its relevance. So, please.
Okay, all right. Mr. Grimms, do you recognize that notice?
I do.
Can you describe what it is and who placed it there and where it was?
It's a notice informing our employees to park off premise. They've been instructed to park in the AT&T lot on weekends and during the evenings, and they've been instructed to park in the metered spots on South Wayne Avenue, West Wayne Avenue, and Bloomingdale.
John, how would you like to mark this exhibit?
I had it marked as Exhibit 4.
You have yes, but we'll have to mark it as what?
We don't have any protestant exhibits yet, I don't
We
believe.
do not.
P4?
P1.
P1.
It's the
This
first
is
of
this is the first
it's the first protestant exhibit.
Okay.
Do you know where your employees are currently parking, Mr. Grimms?
They're currently parking on the AT&T lot, South Wayne, West Wayne, and Bloomingdale,
Why aren't they parking inside of the parking lot?
because I've instructed them to park in those places.
Can you say more about that? I mean, the zoning code basically provides for your providing adequate parking spaces for your employees. We talked about 20 employees, more if you add more seats, and this has a major impact on the other places your employees are parking when they're not parking inside your parking lot.
But the code does not require the employees to park on the premises. It only requires there to be adequate parking for them. It does not require them to be parked
Why?
there.
Yeah, and it's maybe a legal question that I don't want to get into. But
Okay.
it would seem to me pretty normal that if the code requires employees to have employee parking, that employees, in fact, would be parking within a parking lot.
And with all respect, Mr. Sheehan, even with the inquiry brought up with, the vested right / variance by estoppel argument, I'm having a hard time seeing how this is relevant to the elements of the case. It's not relevant if to the extent the applicant is saying, I'm allowed to do this under the zoning code, read it, that's the way it reads. I don't see how this is relevant. And I don't see how the fact that they're not controlling employees, which is an enforcement issue, in accordance with a notice from a manager, is relevant to whether they were led down the lane to believe they had a right to do this.
Perhaps, Mr. Sheehan, and you tell me if I'm wrong in construing this, perhaps he's saying that if they are being directed not to park on the property's lot, which isn't the same, that they are being told not to, isn't that essentially a tacit admission by the restaurant that they don't have adequate parking for their employees and their customers? Park elsewhere. You can't park here. That's what this notice says, and maybe that's what Mr. Sheehan is getting to. Or maybe it's not.
I am saying.
Is that accurate?
Yeah, it's the opposite side. The residents notice the cars from employees parked all day, every day in residential neighborhoods. And the reason is because I believe Mr. Grims has directed his employees to not park within the parking lot, as evidenced by that notice put up on his door employee entrance.
Where they're parking may not be relevant, but the fact they're being told not to park on the property may be relevant. That's what he's saying. For whether you agree with that or not, we have.
Do you recall, Mr. Grims, that on January 27th, approximately, we had a meeting at the Township building with Mr. Bauman, the Township manager, yourself, your attorney, and we discussed the employee parking situation. Do you remember that?
I do.
And that we showed you this notice, and do you recall saying that you had directed that the notice be removed from your employee entrance?
The notice has been removed, and we have directed our employees to park in those areas mentioned before.
Okay. And during that meeting, I asked you whether or not you had directed your employees to park within your parking lot, within the Wayne Town Center. Do you recall?
I do not.
I testified that Mr. Grims, I asked Mr. Grims that question, and he did not answer the question.
Okay.
I don't remember.
Okay. I have one other area I wanted to ask Mr. Grims about, and that is the leased premises. As I understand it, part of the spaces that have been allocated to White Dog Cafe are the unused spaces related to the basement office premises.
I have to object to this, again, relevance. Mr. Bauman testified that we meet the parking for what we have.
Okay. Where are you going with this, Mr. Sheehan?
I think it's relevant because what's relevant is that almost 13 spaces of Wayne Town Center related to office space were allocated to Mr. Grims, to the White Dog Cafe, that have enabled him to seat 39 additional seats. And my question is has he leased those premises?
Well, if he's compliant, then when the use commences on the office spaces, then they'll have to make a showing that they're compliant. Am I right about that, John?
Correct.
Okay, so the point is that he's compliant, and the basement spaces are irrelevant.
I think the issue is what's properly before this board. And the board only has jurisdiction to hear what is properly before this board. What's
Right.
properly before this board is whether the applicant is entitled to operate outdoor dining in the patio with 50 seats, whether under the ordinance or whether under a vested rights or variance by estoppel theory. But it's
Yeah.
only that outdoor area. The outdoor area has not commenced yet, has it?
Right.
You've not commenced operation of the outdoor seating.
No, we haven't.
So
The-
what's
the
there
ba-
now, no one has brought to this board a citation for what's there
Right.
now. It's
Right.
whether they can do this, what they wish to do in
And
the
in
future.
fact, Mr. Baumann said that they are compliant, so,
The basement area is not rented out, so if someone comes in, that gets rented out, they're going to need to come in front of this board and get parking relief because they're maxed out with everything that's open on that site.
Right,
I
okay.
think that's what Mr. Sheehan's referring to.
Or Mr. Grimm's will need to reduce his seats in his restaurant to comply, and will need to issue another certificate of occupancy with those exact seats.
but that is something that Mr. Grimm's and/or the landlord would have to work out
Correct.
on their own. It's got nothing to do with us. Okay. Do you have anything else, Ms.
Those
Sheen?
are all the questions I had. for
Thanks
Mr.
very
Grimm.
much. Does anybody have any follow-up on Mr. Grimm's? Everyone from the board? Okay, thank you, Mr. Grimm.
Thank you.
Mr. Bozeman, do you have any other witnesses?
That's all I have at this time.
Okay. Mr. Rice, do you have anything further?
Ask Mr. Baumann a couple questions regarding A7.
Please.
Mr. Baumann, on A7 that's been marked, these are the prior permits that have been issued for outdoor dining. I'm just going to go through these, and what I want to know from you is whether or not any of these have on-site parking on them.
Weird.
Does Christopher's have on-site parking?
No, they do not.
Parking is all on the street?
Correct.
How about Johnny's Doghouse, on-site parking?
No, they do not.
Bravo Pizza, any on-site parking?
3 in the rear.
Do you know who used the 3 in the rear?
It's my understanding that the employees are using those parking spaces.
Okay. How about Sigma Coffee?
Yes, they have rear parking off-street.
Do you know how many spaces?
I don't offhand, but it's my understanding that any outdoor seating would put them over would make them non-conforming.
Okay. Cosi, do they have any on-site parking?
Yes, they do.
Do you know how many spaces?
I do not.
How about the Great American Pub? Any on-site parking?
No on-site parking.
All parking on street?
Correct.
Matador, do they have any on-site parking?
No parking off-street.
Okay. And the Elegance Cafe, any off-street parking?
They have approximately 5 in the rear.
Okay. Do you know whether they're utilized by patrons or employees?
Employees, from my understanding.
Okay. The other thing I would like to mark and have Mr. Baumann briefly identify. I'm going to mark 3 letters. I'll have him, I've marked as T2.
I'm going to object to this.
What is it? We don't even know what it is.
Well, it's something that I think would be unfairly prejudicial to my client. It's your solicitor could look at it. It's
John, can you just tell us what it is?
It's a violation notice that says that they're beyond, have too many seats for their current certificate of occupancy. And I don't think this notice is fairly before us in this proceeding. I mean, the question is, can they, I have to, I'm sympathetic to Mr. Brosman on this. I think the question is whether they have a right to conduct the outdoor dining. We've just been testified that they're compliant with parking, so that this violation notice, is at odds with that, but I don't think it's before us. I think that what's before us is whether they, under the reading of the ordinance or under a vested rights theory, have the right to conduct outdoor parking without, outdoor dining without providing additional parking. They have to make their piece of the township on the rest of their operations, but that's not before us tonight.
John, what's your argument on its relevance?
Well, there's 3 documents here, 3 letters. There's a letter dated December 3rd, 2010. This is and Mr. Baumann can testify that this was a meeting that was convened as a result of a violation of the indoor parking seat. There were 174 seats counted at that time.
Without telling us too much about the substance,
that was
then
incorrect.
Generally,
and then the other 2 documents pertain to this ongoing
situation.
seating problem. So if we're going to you're going to make a decision on what's been asked other than the interpretation, whether it's a vested right, and there's an element of good faith in a vested right case, and I don't think this is a vested right case. It may be a variance by estoppel case, but I don't think that it's a variance by estoppel case either, because they're relying on what other people have gotten. All those cases deal with reliance of a property owner's use on their property, not on what somebody else did. But they've raised it, so there's a good faith element here. And I think this board is entitled to know whether this particular operator, this restaurant, has been in violation over the past 6 months. This has been an ongoing issue, the moving of seats in and out of the indoor dining.
Yeah, but I have to, my response is, the question, I think, first of all, commenting personally, and the board will have to make its own decision, I don't see either a vested rights or a variance by estoppel. Those are extremely difficult things to attain. I agree that with Mr. Rice that generally it's an issuance of a permit which triggers a vested rights discussion.
I'm going to sustain the objection,
but I think
I don't think it should come in.
I think, but that they're basically, if they're okay on one thing, the fact that they're not behaving themselves on some other thing is irrelevant to that.
Well, as a matter of law, John, can I ask you, is a claim of variance by estoppel addressed the equity powers of the arbiter? Is it? I mean, as a matter of law, is it or isn't it?
I don't think it's technically it's got equitable connotations, but frankly, I'd have to reread it to see whether it's the same as equity.
I think giving John Rice's
I think
due.
it's straight up. I think it's straight up equity. I think it's just straight estoppel in the context of land
Well, if
use.
that's what it is, then determining the clean hands of the requester of the relief, we are entitled to hear that and give it what weight we think it deserves. Because if we're talking to the equity powers, clean hands is an issue, and this would be relevant. If we're talking otherwise, if it's not equity, then it's not relevant, because they say that if they're in compliance today, whatever that problem was, it's been cured.
Yeah, but the clean hands has to do with what's before the board.
Right.
If they've behaved, if they have approached with clean hands the question of can we have outdoor dining, the fact that they've done other things on other areas that one might not think are so attest to clean hands does not suddenly intrude into this area.
But it's all parking. It's a matter, are they or are they not following the limitations based on
But they've not been cited for
parking.
existing parking. They've not been cited for existing parking.
Gentlemen, my ruling stands. Let's move on.
Well, just, I'm done then, but this is by way of an offer of proof then. So it's in, I understand it's not being admitted, but I still need, I think, to identify what these 3 documents are in terms of.
Okay, you can put them in. Let's put them in a letter dated blank from A to B.
There's a letter dated There's an internal memo dated December 3rd, 2010 from Matt Ballman to his file. There is a second internal memorandum dated May 17th, 2011 from Matt Ballman to his file. There's a letter dated May 18th, 2011 from Matt Bauman to Mr. Marty Grims.
Okay. Thank you. Did you have anything else, John? Okay. Mr. Brosman, did you want to wanted to get your exhibits admitted to the record?
Just T1 is, I'd move that they be T1 be accepted.
Okay. And Mr.
And you will
Brosman?
provide copies of T1 to everybody?
Matt will print out some more copies and distribute those.
One for Mr. Sheehan as well?
Correct.
Did you want George, did you want to get your exhibits admitted to the record?
Yeah, could I ask Matt a follow-up question?
Of course.
Based on his last questions with John Rice. Matt, you went through all the restaurants that had, in A7, the ones that were issued outdoor dining permits, and John Rice asked you which ones, to your knowledge, had any parking and which ones had no parking on the properties. Did the fact that a property had no parking, was that any part of the reason why they were granted an outdoor dining permit?
No. I mean, I guess I'm not real clear on your question. Whether they had parking or no parking, was that a factor in my decision or a decision being made?
Right. Whether when these permits were issued, were any of them approved to have outdoor dining because there was no parking on the property?
No.
That's all I have. And I would
Thank you, Mr. Brosman.
ask that my exhibits be moved into the record.
Okay. Thank you. For the record, the board, the township actually, Mr. Bauman received a letter dated May 13, 2011 from Michael Mayura, Manager, Office Services of the Lumbermen's Merchandising Corporation. For the reasons that I expressed in not admitting the various materials that Mr. Rice had proffered regarding matters that I found to be irrelevant, I similarly am going to find that this letter, I have read this letter and I find that the matters raised therein are also irrelevant, and I'm not going to admit this into evidence. It will, however, be part of the file. Is there some designation I need to put on this, John?
I would call it L for letter 1.
Okay.
The author of that letter, if they wanted to assure themselves of party status or have their best chance of party status, would do well to appear in person if the hearing is continued, because that's the way you become a party. And I agree with your thoughts as the substance of that letter based on our earlier discussion of the other materials.
Is anyone from Lumbermen's here tonight? Okay. Thank you. All right. Well. I will accept limited, please. It's 10:15 and we've only gotten through one of these. Limited comments, please, from the audience. No, we are at the end of this application.
Thank you. I'm Jim Schneller. I live in Wayne.
Wait, yes, please, Mr. Schneller, please be sworn.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
And state your full name, please.
James Schneller.
Okay, Mr. Schneller, you're not seeking party status, is that correct?
I'm only not seeking party status because it would cause a time-consuming discussion.
We thank you for that, Mr. Schneller.
And I see that there's an issue in the next appeal, which is very identical.
If I may, then
I'll present it there.
That's fine.
However, I just got up to say that I was hoping that the map could be enlarged so the public could see where this patio is supposed to be.
On the next one?
No, on this,
on this one. Okay.
If you could bring the map out.
Well, it's directly adjacent to, it's parallel to the sidewalk and to 30, and to Lancaster Avenue.
It's on the front?
Yes, it is. Is that correct, Mr. Brosman?
Jim, come here. I'll show it to you. Right here. This is Lancaster Avenue. This is the building. The patio is existing, it's there, it's surrounded by a barrier. It's not being used, but it exists physically.
And a point I'd like to make is that I am a citizen who has gained some measure of standing in two different matters, showing concern about influx of liquor licenses into the township.
That ship has sailed as it relates to this one. He's already permitted. He's already got his license.
Well, we believe, though, that this will cause a net increase. It is kind of a constructive.
This board is
Mr. Schneller.
specifically prohibited from regulating liquor
That's
licenses.
that's an issue you might want to take up.
So
with
if that would relate in any way,
it doesn't relate in any way. My apologies.
Snowballing issue. Thank you.
Sir, come up and state your name for the record. Be sworn.
Sir, if you'll raise your right hand, you come to tell the truth, whole truth, nothing but the truth.
I do.
State your name for the
John Shane, neighbor Wayne. In this map, we're adjacent to this as a local community on Windsor Avenue, so we're very close to all this. So I obviously I'm not going to be party to this, but I do have to ask a question as a taxpayer in this area.
Shoot.
By the testimony I've heard tonight, we have a institution that built out 176 seats, bought over 100 seats for outdoor furniture, 276, which is not what they were ever given the certificate for.
Well, I'm sorry.
Well, so my issue is that based on their plan, they have planned all along to maximize and to continue to use more seats than what we have ever given them licenses for in this township.
Well, I'm not sure that the record supports that necessarily.
Well,
but the point, but they are compliant.
It does do that.
But Mr. Baumann has already testified that they are currently compliant.
As of today, they're currently in compliance.
That's what's before us.
As of today.
What has transpired in the past has already been ruled to be irrelevant.
Well,
okay.
I hope your decision will remain relevant to the testimony tonight.
Okay. Thank you. Mr. Sheehan.
Yes, I had three more exhibits I wanted to introduce as evidence.
Okay. Do you have copies for Mr. Rice and for Mr. Brosman?
Yes, I do. I have copies for everybody.
If I might, Mr. Sheehan, what do you propose to show by your exhibits?
This is a photo. You want me to wait to get to the microphone?
Sure.
This is very brief. It's a photograph of Lancaster Avenue in front of the White Dog Cafe. I took the photograph on February the 11th. What it shows are vehicles stacked up all the way to the curb with a vehicle on Route 30 eastbound waiting to enter the parking lot. And westbound, a vehicle attempting to make a left turn into the parking lot. Conditions like this occur just about every day of the week, weekdays, during lunchtime, busy hours. My basic point is that by adding 50 more seats of capacity to this restaurant will aggravate this already dangerous situation. My next two exhibits are related. I'll pass these out first. This, the last exhibit, I suggest numbering it P2, the photograph, and this one in your hands as P3. And what this exhibit is it's basically a summary of a traffic study which I did basically trying to figure out how many average customers per vehicle were arriving at the White Dog Cafe. Here's where it's relevant. The relevance is the code requires one parking space for each 3 seats in the restaurant. The very limited survey which I did, which took place on February the 14th, beginning at about 12:20 p.m., I observed 19 vehicles arriving in the parking area where I could see the people going into the White Dog Cafe. There were a total of 25 people in those 19 vehicles.
Mr. Sheen, you did this one day, one time?
This was
one day.
This all happened within about a 1 hour period.
And do you really think that's a fair way for us to take a snapshot?
You know
of
what?
this thing?
I don't, to tell you the truth. However, there has been no evidence indicating actual conditions that have been submitted by anybody. And in addition to that,
the code
Yes.
the code doesn't require people to go back and count and see what the actual experience is.
Right.
It requires, one space per 3 seats.
I understand that.
And so if your observations show
Right.
that ratio isn't appropriate, then we're stuck with it as a board. We're stuck
Right.
with what this book says. And your remedy would be to go to the commissioner and say your ratio is screwy and doesn't really
Right.
comport with the reality.
What my point is by adding any more seats will do more harm to the residential neighborhood and other
But we could only
areas.
consider that if they were asking for a variance, but they dropped that request.
Well,
So public health, safety, and welfare issues are not something that's going to come into this case.
Maybe I misunderstood. I have the impression that they're here before you asking for the ability to have 50 more seats in outdoor and
Yeah,
dining.
but they're only making a legal argument.
It's a little more complicated than that.
Yeah.
This isn't originally they had a variance request.
Right.
They've withdrawn that. So they're
Okay.
alleging legal technicalities of variance by estoppel or vested rights. But other than that, there's no variance case before us. So this is really not relevant to what we have to decide.
This is not
I know
the
it's important to
typical-
you.
Yeah, this is not the typical
Yeah,
case
I have
where
a-
all that stuff
yeah,
would be.
I
appropriate
hear
for us.
what you're saying. I don't fully understand it. I have a hard time believing that adding a significant more vehicles to that business would not aggravate an already bad situation of traffic and hazards.
It very well may, but the problem that we have is that those concerns of public health, safety, and welfare, oddly, aren't relevant because we're only hearing a legal argument. We're not here on a variance application, which is when we would consider those issues.
Okay,
Does that get a little bit clearer for you?
not much. Tell you the
My
truth.
apologies.
Not much.
Stick around after the hearing, and we'll explain it to you so you'll feel a little better.
Okay. I reserve the right to come back with these exhibits then. I won't waste your time. You're basically saying it's irrelevant. I don't think it's irrelevant.
Well, it is
But
not
I-
irrelevant
but it's
where we
not
hear on a
necess-
variance application, but
Right.
insofar as we're here on a purely a legal question and/or a vested rights variance by estoppel,
Yeah.
it's actually not.
My impression from being here was that, looking at a overview of the area around the restaurant, the valet parking, I think the number of vehicles is pretty relevant. But, I'll yield to your
We won't say
your
collective
legal
wisdom, we'll just
reasoning.
say experience. How about
Okay.
that? Anyone else from the audience? I'm sorry, Mr. Sheen, did you have anything further?
No.
Okay, thanks
you.
very much. Anyone else from the audience have any comment? Okay. I guess we'll finish for this evening. I think members of the board, I can speak for myself at least, that I would like And we have the benefit of a brief from Mr. Brosman, and to the extent Mr. Sheehan would like to make a written submission, I think the board would find that to be very helpful. Mr. Rice, if you'd like to make a submission, that would be great. We'll hold the record open in case you have anything further down the road you'd like to present in terms of additional evidence. Mr. Brosman?
I would like to fully, and to ask the applicants, consent to this, to hold the record open fully for all purposes till the next hearing. And to the extent parties wish to submit briefs, I'd like to have them in within 7 days prior to the next hearing.
So you want them served on you and all counsel for other parties?
Yes.
On the same day?
On the same day. And service has to be done by, does anybody have a calendar? The next hearing is Thursday, the
15th of June, right?
I think it's June 16th.
16th? I think that's right. What is the preceding Friday
That was
date?
canceled. I'm sorry, John.
What's the date of the Friday that precedes that?
Calendar in your BlackBerry.
Friday the 10th? I'd like to see any briefs submitted, served on all council, the township, and me on behalf of the zoning board by 5 p.m. on Friday, June 10th.
Okay.
And then I think in deference to the applicant, Mr. Brosman should have the right to supplement his brief. Some questions have been raised by the board, and he should have as much chance to respond to them as anybody.
Okay. And when would you like Mr. Brosman's reply?
I think all the briefs ought to be in. We can do one thing. We have reply briefs. We just say,
Well, hold on.
everybody get your briefs in by the 10th.
Here's my thought, that Mr. Brosman has presented his brief, and then we'll get some additional briefing. He should get a chance to reply.
To everything.
Yeah.
All right. That's.
So how much time do you need to take a look at his?
Well, I think for Mr. Brosman's brief, if everybody else's brief was in by close of business on Friday the 10th, could you get your reply brief to me by any reply by close of business on Tuesday? Is it the 14th? It's tight, but I mean.
Why don't we make the briefs due
A little earlier, shift them back a bit.
move them back to Thursday, and then give him. So he'll have Friday, Saturday, Sunday, Monday to look. If you want to have it on Tuesday, if you want to have the reply on Tuesday of the week of the hearing.
Tuesday, it only gives me 2 days. I really would prefer it on Monday and shifting the schedule back to accommodate.
Okay. How much time do you think you need, John, for your brief? I do this and
About tomorrow by noon, John.
I don't want to have anybody
Brief and
short.
attachment
That's
was
all.
like 60 pages, I think.
Yeah.
wasn't
Yeah,
it?
but a lot of
I want to
those
give you as much
exhibits-
time as you need, and I want to give him as much time as
The
he needs.
attachments were most of it.
The Monday of that week of June 10th, whatever that is, that's fine. I don't intend to. These are pretty narrow issues that we're dealing with. So whatever that is,
That's D-Day.
The
6th.
June 6th, D-Day.
Okay.
Okay, so, and then Mr. Brosman's memo would be the following Monday, right? Which
Right.
is Monday.
The 13th.
13th?
Yeah. If it's yeah. You okay with that, Mr. Brosman?
Yes, that's fine, thank you.
So
Okay.
everybody but Mr. Brosman who wishes to submit a brief has to get it in by close of business on June 6th, the Monday, and that's 5 p.m. And Mr. Brosman has, for anything he wishes to file in response or otherwise, until 5 p.m. on Monday, June
Right.
13th.
And the factual record is open for all purposes.
And the record is open. And Mr. Brosman, would you agree to a continuance of the hearing until the June 16th meeting with the continuance of the hearing and our extension of the 45-day period for rendering decision to start thereafter?
Yes.
Mr. Sheehan, you may want to come up and tell everyone your address for service purposes so they can put that in the...
It's 409 Windsor Avenue, Windsor, Wayne, PA 19087.
Do you have an email address that could
Yes.
be used? Mr. Rice, Would it be possible, when the brief comes to me, I'll serve the zoning board. Can you make sure that other people are served through the township's copy, including Mr. Sheehan?
Mr. Rice is going to need one. He's got to serve you.
Yeah. And electronic briefs are great.
Did you have a copy of Mr. Sheen's card?
He gave it to me.
Okay, great. All right, so anything else on this application? Okay, I guess we're done on this one. We can move on to the next one. Okay, we'll take a 5-minute break, and then we'll move on to the Zilantro application. Thank you. Ladies and gentlemen, we're about to begin. My paper. Borrow this. The next matter we'll be tackling this evening is appeal number 2855. The applicants Zalantro of Wayne, LLC, and 100 East Partners, located at 103 North Wayne Avenue, Wayne, PA 19087, and is zone WBOD, seeks approval to operate an accessory outdoor dining area with a maximum of 34 seats in conjunction with the Zalantro restaurant, a restaurant that is now under construction. The proposed outdoor dining area would be located on the outdoor patio area. The applicants contend that the parking requirements of Code Section 280-5312B5 do not apply to outdoor dining in the WBOD. Alternatively, applicant contends that there is a vested right to proceed with the outdoor dining, or that a variance by estoppel should be granted to allow the proposed outdoor dining. Mr. Brosman, when you're available.
Yes, George Brosman, representing the applicant, Cilantro Wayne Investors, LLC. As we did with the last application, I had a question about standing. I had received a letter from Mr. Schneller where he attempted to enter his appearance in this matter, and I wanted to object to that.
Okay. Let's do. As an administrative matter, we do have a letter from Mr. Schneller, dated May 16, 2011. To the Zoning Hearing Board and Department of Community Development, I'm a resident of Radnor Township and am aggrieved by the circumstances present in these appeals, and those, one of them is with respect to 2855, which is the subject of the appeal we're discussing now. I request abeyance and a continuance of appeal number 2855 because the property in question is the subject of pending litigation at Commonwealth Court number 140 CD 2011 and Commonwealth Court number 277 CD 2010. Both of these appeals, in which I am appellant, deal directly with issues regarding use, propriety of township action, violation of land-related statutes by the landowner, and in the former unresolved zoning issues pertaining to the property at issue. Enablement of this request will streamline the resolution of the entire circumstance. Sorry. Sorry. Enablement of this request will streamline the resolution of the entire circumstances, prevent redundancy, allow for developments in the law and or docket, and will promote legality, justice, and fairness. I request continuance also due to my work schedule and due to the lengthiness of the agenda for the May 19, 2011 board meeting. I am faxing an appearance form with this letter. I claim full and valid standing. And attached to this is a entry of appearance by Mr. Schneller post se.
Mr. Chairman, it seems to me the first issue is whether there's standing, and then whether, if there's no standing, I don't think there's the ability to argue the propriety of other litigation and so forth. If there's no standing, it seems to me that would, so I think the standing is a threshold issue that the board should address.
Okay. Mr. Brosman, would you like to question Mr. Schneller on standing? Mr. Schneller,
yes.
If you could come up, please, and be sworn.
Good?
Yes, please.
You promise to tell the truth and
I do.
And state your name for the record. Sorry.
James Schneller.
First name?
James.
Thank you. Mr. Brosman?
Mr. Schneller, where do you reside?
At St. David's Park Condominiums, which is at 550 East Lancaster Avenue.
Excuse me 1 second. John, in connection with the prior proceedings before the board with respect to this property. Did we make a ruling as it relates to Mr. Schneller's standing?
Yes, we did.
And can you tell me what that ruling was?
The ruling was that he had no standing in that
Is
case.
is that insofar as it's the same property, not the same application, but is that
I think that is
raised judicata?
Extremely relevant.
Well, it depends if anything's changed. Maybe he's moved or owns property around the corner or something.
Fair enough.
Unless
Thank
there's
you.
Any facts
circumstances that
changed?
my recollection of that proceeding was that Mr. Schneller's residence is located at least 3/4 of a mile from the property in question. He owns no other properties or real property interests that are closer than that. I recall the testimony being that you could not even see the intersection of North Wayne and Lancaster Pike from his residence, let alone the property in question. And on that basis, the board, I believe, quite correctly ruled that there was no standing.
Okay. Mr. Schneller, is the question of your standing in the prior case, is that one of the issues that you've appealed to the Commonwealth Court?
Yes.
Okay. Have any circumstances, have you moved since the prior case?
It depends on the depth of your...
No, I'm just asking if you moved your residence, that's all.
Well, if I could say that if the board remembers, there was quite a bit of argument, in fact, on my part, regarding levels of standing that go beyond geographical distance. And there have been changes in the circumstances.
Okay, first of all, can you answer my question as to whether you've moved your residence?
I have not changed my place of residence.
Okay. Have you bought any property in the township since the last proceeding on this property?
No.
Okay. Can you tell me briefly what your position is on the change of circumstances?
If I could make a brief statement, I'm not sure that the law of the case really is going to apply here. This is a brand-new proceeding.
Well, the question is
It's a completely
standing.
different question.
Well, the question is still standing, and the property is exactly the same. So from a legal analysis perspective, nothing has changed as it relates to your standing to object to development on the same property.
Well, we're talking about someone who's made a completely different application. It's a different matter.
Okay, well, that's actually fair. And so what is your contention as to why you have standing?
My contention, to run through what I had stated before, and I still stand by it, is the fact that I'm a daily, I traverse the place almost daily. I have, in fact, increased my standing, if you will, because of various other issues I've pursued in the immediate area to some extent or other. There was a matter I brought up before the Board of Commissioners about one of the trees was wrongly cemented right here where this improvement was built on the sidewalk. And I have fomented, I would hope, replacement of the cement with some kind of a metal grating. Okay. All of this gives me little increments of standing, and I ask your perception of what I'm saying as cumulative.
Okay.
I also am a frequent visitor to downtown Wayne, and I happen to have the fortune of riding a bicycle almost exclusively as my means of transport. And I've always claimed that this gives me an acute sense of issues regarding movement of traffic and movement of pedestrians, where I often walk my bicycle. And I also just happen to be a proponent of this type of comfort and safety emphasis that I would hope the township in general upholds, and that I hope you're helping by way of keeping the code in place.
Okay.
I also claim, and this is brief, I claimed, as I have in the prior case, that I have taxpayer standing. Now, my rent just went up again this year. I'm paying a healthy portion of taxes to Radnor because my landlord obviously is paying what I'm not directly. I also have claimed all along that what's happened at this particular property has had a fair amount of statutory violation, township and state. And there is a policy or a doctrine of standing called the private attorney general standing, is a name one court gave it, where a citizen, if no one else has stood up to make this point, and this point is a worthy
Well,
point.
hold on. Are you contending
So I claim standing under the private attorney general.
in this case?
Yes.
I think the township's making an appearance in this case as well. So it's not that nobody has. Is that right, Mr. Rice?
Yes, Township's entering their appearance in this case. And just to, I was here at the prior case when the board involving the exact same property, Mr. Schneller hasn't moved, and the board denied him standing. He never appealed that decision. He never appealed that to the Delaware County Court of Common Pleas. What he did was then he filed a complaint in District Justice Court, who dismissed it. It went to Delaware County Court.
On the dismissal.
On that appeal from the dismissal by the District Justice Court,
That's what I thought.
it went to Delaware County Court, who we filed preliminary objections. It's been dismissed. It's now in front of the Commonwealth Court.
On the POs.
Yes, on failure to pursue a statutory remedy, actually.
Okay.
I mean, what we raised was that your ruling on the prior application on his standing should have been appealed under the MPC procedures, statutory procedure. He did not do that. So
Okay.
that's where that case is. Actually, I believe he may have filed a brief last week. I have a brief on that dismissal due. But it's the exact same case. We're in this case also representing the township's interests.
Okay.
And a 30-second response to that, it's important to note the Superior Court issued a rule to show cause about quashing the appeal. They didn't.
Okay.
And I know, I don't want to just review the case. However, the municipal court was quite aware that I did that to avoid claims of litigiousness that were humming around like bees that spring. This would have been my third appeal from this township in the Delaware County Court. And so I filed this matter with a valid reason. I claimed that
Okay.
I can keep it short. I claimed that because the board...
But you know what? Even short, it's not really relevant to your standing
right.
here. Okay. Just with all due respect. Are there any other facts you want to bring in about your facts now about why you have standing?
Yes, I was saying no other citizen has stood forth with this. I believe I have standing because the public knows that I'm someone who has stuck with this case.
Okay.
And this may have caused or prevented other people from coming in. People are very busy. We know that in Radnor Township, people love to watch these meetings on the television, however. This has come out in the past month or two.
Which makes me feel great about this.
Well, I hope that's the only camera.
Mm-hmm. Yeah, okay, go ahead.
This will not sound very factual, however, my circumstances are, first and foremost, that I have come in and claimed that I am deeply affected. I'm not claiming to be affected like the population. I'm giving you specific reasons.
Okay. Mr. Schneller, I'm going to have to, we're going to have to make a decision on standing here.
Well, I have more to say then.
Okay, well,
Because
to be, with all due respect, we have heard enough, I think, for us to make a decision as to whether or not you have standing on this case.
Well, I wanted to summarize that, though.
Okay.
The fact that there are...
Believe me, we understand your position. We have heard it before, with all due respect. And you will have an opportunity at the end for public comment.
I would ask that you keep it under consideration during your review and during the presentation of the applicants. You don't have to decide immediately. I think I've gained at least a measure of standing, so that might be an option.
Okay, well...
And frankly, the matter is not one of distance, and it is one of a citizen who's not affected like citizens overall and who has specific circumstances.
Okay. All right.
If I could mention again the fact that the taxpayer status that I claim will cause you to think, well, that requires someone who's not just coming in and claiming to be a champion of the municipal code. And the private attorney general theory, on the other hand, is about a citizen who wants to stand up.
Okay.
But they both apply.
Okay. All right. I think we fully understand your arguments, and I think I would, my,
And my ultimate participation request, my ultimate
ahead.
participation request is made solely because the deeper the issues, the more someone should be here standing up for them.
okay, well, we have counsel for the township here to stand up for the citizenry of the township.
I
So,
claim-
Mr. Rice is a very well-respected land use attorney and knows this stuff better than most.
Well,
So
I
he
claim-
is acutely aware of the issues and well able to defend the rights of the citizenry of the township.
I don't think the interest that I would stand up for will barely be grazed, and it's not a criticism.
Okay.
But
Well, I think I'm ready. Let's move on and we'll handle the standing question. It would be my recommendation to rule that Mr.
Is this a matter of ruling or a matter of motion? Do you need a motion?
I'll entertain a motion. Is there a motion?
Yes, I move that we deny Mr. Schneller standing in this
Is there a
matter.
second on the motion?
Yep.
All in favor of a motion deny Mr. Schneller standing? Aye.
Aye.
Any nays? None. So the board has ruled that you do not have standing. But again, Mr. Schneller, you will have an opportunity to raise your concerns at the public comment portion of the program. Thank you. Mr. Brosman.
Thank you. Again, George Brosman representing Cilantro Wayne Investors LLC and 100E Partners. Cilantro is the lessee of the property at 103 North Wayne Avenue in Wayne, and 100E Partners is the owner. I was going to hand in Exhibit A1, which was my application. And this application did contain the lease.
Okay. While you're handing it out, Mr. Brosman, I think, ladies and gentlemen, we're going to close this hearing tonight at midnight because that's frankly all many of us can take. Midnight. If we're close to finishing, maybe we'll run over a little bit, but if we're not, then we'll end at midnight and pick up where we left off next month.
Mr. Chairman?
Yes.
Would you mind asking all the board members to use their microphone now?
Okay. Members of the board and Mr. Ryan, if you could please remember to use your microphones.
Thank you.
This property at 103 North Wayne Avenue is also in the Wayne Business Overlay District. It is one property removed from the corner of Lancaster Avenue and North Wayne Avenue. I was going to call Mr. Bauman to testify, but I might be able to incorporate his testimony into this from the last hearing. I think the questions I would have and the exhibits I would have would be identical. And then I was going to call Joel Solomon, who's in the back. He's one of the principals at the Cilantro restaurant. And I have Joe Birch from the ownership entity, 100E Partners, which is an affiliate of S.W. Bages.
Okay. Mr. Rice, would you have any objection to incorporating the prior testimony of Mr. Bauman? No? Is there anybody in the audience who would have an objection to incorporating the prior testimony by Mr. Bauman? Okay. What's the nature? Well, you're not a party, sir. We've already ruled you don't have standing. Thank you. John Ryan, do you see any trouble with that?
No, I think that if we're going to do that, though, we're going to have to introduce into this record the transcripts of testimony of stenographic transcripts of testimony of Mr. Bauman's testimony from the prior record.
Why don't we do that? Why don't we?
If everybody has no issue with that, we could.
You could, George, you can give them limited examination and use an entry you testified in connection with blank, and do you incorporate your testimony, something along those lines here?
Mr. Brosman, while we're all at it, there are certain exhibits from the last hearing that I assume you're going to put into this hearing, such as your copies of the ordinance, the drafts of the ordinance, and things of that sort. I think the only thing from the prior hearing that we would not want to get into are the protestant exhibits and the testimony about the operations of that particular site. So I think it's actually a fairly broad incorporation. We might save some time.
Yeah, I think it's all of Matt Bauman's testimony and all of the exhibits relating to the adoption of the Wayne Business Overlay District Ordinance.
And also the Exhibit A7, which was, I assume you're going to want to put the list of the various establishments that were permitted.
That's
and the
right.
Testimony about that.
That's right, all of those.
Would it make sense to just really quickly go through
Yes, it would.
the exhibits that we're going to incorporate by
I'm
reference?
thinking just because in the last one, the numbers probably won't match up to this one.
Well, then we can just incorporate them by reference.
Yeah, so I
okay.
think it's a good idea.
Can I just make I'm looking at the list of exhibits, and I think from the last hearing, I'm assuming, I don't know, did you have a variance request on this case too, Mr. Brosman, that you're withdrawing?
There was never a variance request
this.
on this. There
Okay.
is the vested right on this, but there was never a variance on this.
Okay, because that was but A3 is the March 15th, 07, Delaware County. This is from the last hearing, Planning Commission meeting. A4 is a WBOD draft. A5 is Matt Bauman's letter to the Delaware County Planning Commission dated May 24th, 07. And A6, the WBOD draft of June 18th, 07. And A7 is the records of the prior outdoor dining approvals. So I think they're all the same documents for this hearing.
Yeah, no, okay, just to reiterate, A3, if these are from 2854, A3, A4, A5,
A6,
and A7.
A6 and A7. Yeah.
A5, A6, and A7.
So it's, can we say that the exhibits A3, A4, A5, A6, and A7 in this proceeding will be the exact same exhibits as A3, A4, A5, A6, and A7 in Appeal 2854.
That's right.
Okay.
That's fine.
So I don't think we need to put those exhibits in again unless the township should may want to copy them for the file or some such. But
All those trees killed for nothing, George.
We'll recycle.
We should take our own exhibits and put, no, they're the same exhibits. In other words, do you have an A1 already, which is your application?
We have an A1, and I guess to keep the record clear, we'll note that we're skipping A2.
Okay.
And then we'll just pick up with A3 through A7, which we're incorporating. Was it A7? Was that the last one?
Yeah.
Okay.
And then I'll pick up at A8.
Yeah, A8 and the last one was the lease.
I think the ones after that were specific to that. There was the lease, there were the certificates of occupancy, there were the notices, there were the protestant exhibits. All of those are specific. So
Right.
what we're incorporating by reference here is all of Matt Bauman's testimony and cross-examination in Appeal 2854, and as well as exhibits A3, A4, A5, A6, and A7 from 2854, which will have the exact same exhibit numbers in Appeal 2855 as they had in 2854.
Yes, I think that's right.
Great.
Yep. Agreed.
So I'd like to call Joel Solomon.
Mr. Solomon, if you'll come up and state your name for the record and be sworn.
It's Joel Solomon. I do. Joel Solomon, Solomon.
Joel, are you, along with Luis Marin, who's in the back here, are you going to be the operators of the Cilantro restaurant which is about to open at the property which is the subject of this application?
Yes.
And does the entity known as Zalantro Wayne Investors LLC lease that property from the owner of the property?
Yes, it does.
And what is your position with Zalantro Wayne Investors LLC?
I am the president and CFO.
And application A1 that I submitted was a copy of the application we filed to the board. That contained the lease to the property. Are you familiar with that?
Yes.
Is your lease still in effect?
Yes, it is.
When Zalantro Wayne Investors rented the property, were the restaurant improvements built out in the space, or did you fit the space out to meet your needs?
No, we had to fit them out to meet our needs. It was virtually a shell.
And did the build-out involve a substantial work and substantial expenditure?
It absolutely did, yes.
And are you generally familiar with the property and the surrounding area?
I am, yes.
And what's your experience in the restaurant business?
I represented restaurateurs in the past. I've represented restaurant investors in the past. And my partner is the day-to-day restaurateur with 20 years of experience.
So Luis is sort of the day-to-day operation person that would be running the restaurant?
That's correct.
And describe what Zalantro restaurant is going to be.
It's an upscale Mexican restaurant with, we plan to serve fabulous margaritas and other alcohol as well.
And when do you plan on opening to the public?
Our plan is the beginning or middle of next week.
And have you received a certificate of occupancy from the township?
Yes, we have.
And did you receive a food establishment license from the township?
Yes, we have.
And I had pre-marked my exhibits, so since we incorporated, I'm one digit off, so I'm going to change what I had to A7 as A8. Is this A8 a copy of the certificate of occupancy?
Yes, it
that
is.
you've received?
Yes.
And A9, is this the food establishment license that you received?
Yes.
And if it's okay with the board not to take up time, I won't remark every one of these. I'm just saying for the record they're A9 and I've changed the top one. Should I give that to you, Mr. Ryan?
Yeah, I think I can scriven off and on while I listen. Yeah, actually, if you get your exhibits, when you get if you still have A7 in red without a change, make it A8, and if you still have A1 in red, make that A9. Isn't that right, Mr. Roseman?
The others are in blue, just to make it confusing. And it's A7 and A8. 7 should change to 8, and 8 should change to 9.
Okay. Oh, okay, that was an A. Okay, so up them one.
And was an application for a 34-seat outdoor dining area for Zalantro filed with Radnor Township?
Yes, it was.
And there's an outdoor patio area in front of the building, between the building and North Wayne Avenue, is that correct?
Yes, that's correct.
And is it on that outdoor patio where the outdoor dining would be located?
Yes.
And just to give the board an idea, I have a photograph here that is A9. Is that a picture of the front of the Zalantro while it was in an earlier stage of construction and the patio is in front of it?
Yes, that is.
Does this one have the right number on it? This is A10.
Oh, that's right. That should be A10. And is this outdoor patio area an ideal place for outdoor dining?
Absolutely, yes.
Now, just for the record, in the Exhibit A1 that I filed, there's a letter from Mr. Bauman indicating that he had denied the outdoor dining for two reasons. One, because it didn't comply with the parking required by 280 5312B5, and also that it was necessary for there to be a food establishment license for the for Cilantro. Are you familiar with that?
Yes.
And we did not appeal the determination that we needed to have a food establishment license, and you, in fact, since received the food establishment license, correct?
That's correct.
And that was one of the exhibits we handed out earlier?
Yes.
And are you generally familiar with Code Section 280-5316, which are the accessory outdoor dining regulations for the Wayne Business Overlay District?
Yes.
And have you requested any variances from those?
No, I have not.
And when you were deciding whether to lease the property, was the use of the patio for outdoor dining an important part of your decision to lease the property?
It was one of the primary reasons we leased the premises, yes.
And did you confirm with the landlord that you would be able to have outdoor dining there?
Yes.
And were you aware that other outdoor dining has been allowed in the Wayne Business Overlay District?
Yeah, absolutely, yes.
And did that give you additional comfort that there should be no problem having the outdoor dining on the patio area?
Yes.
That's all I have for Mr. Solomon.
Mr. Rice, do you have any questions for Mr.
Just
Solomon?
one quick question. Other than this, the application that was denied by Mr. Bauman that results in the zoning hearing board application, you don't have any other permits or any other approvals or anything else in writing that states that the outdoor dining is permitted, correct?
That's correct.
Okay. That's all I have.
Do any of the members of the board have any questions? for
I
Mr.
guess we can
Solomon?
assume it's going to be a fun place because the occupancy certificate allows you to have 86 people and 60 seats. That's going to be very intimate dining, isn't it? I guess it's the rest of its staff.
I think that
huh?
includes our employees, too. So.
I have a question either of Matt or you, Mr. Solomon. How was the original indoor seating approved, and how was the parking requirement met?
Well, I need to understand better that it's been a while, but maybe George can clarify. How many parking spaces are in the rear? Is it 7? I don't remember offhand.
I think there's 3.
There's 3 in the rear, and there's 2 metered spaces in front approximately. But, I mean, this goes back to prior to myself.
Yes.
I do.
Good catch.
This goes back to the permit that was issued a few years ago when it was proposed to be an ice cream store, and I think it was going to be 69 seats. There was a change of use permit that was authorized by my predecessor, and since then the solicitor and I have talked about that, and this is really why they're here today, without going for the indoor dining to the zoning hearing board because of this change of use permit that was authorized. So to answer your question, I mean, I think, Peter, that no, they don't meet the current parking requirement with 60 seats.
Okay.
But the township is not contesting that they can use the inside of the building
No.
As a restaurant because it was previously an ice cream parlor.
And it was approved under some non-conforming change of use theory by Matt's predecessor. They relied on that permit, they proceeded to do work on reliance on that. So that's not an issue from our perspective. Just the issue on the outdoor dining and parking that would be required for the outdoor dining seats.
Well, Matt, under 53.12, they're entitled to use the on-street parking. There is metered parking, isn't there not, in front of this property?
I believe there's 2 spaces.
Well, I mean, it doesn't have to be right in front of their property. It just has to be on the street that is at the front of the property.
That's correct.
So the entire North Wayne Street plus the lot that runs off of it is all metered parking, right?
That's correct.
I think that
Although it's defined in the Wayne Business Overlay District that the on-street parking is defined as being on the street that runs in front of the property to qualify. So they do qualify based upon metered parking, even if they had no spaces.
Correct.
Yeah.
And I think, as was stated, the permit that was issued was basically on a non-conforming. There was a certain degree of non-conformity based on what was there, and there was a determination made that what was going inside wasn't going to increase the degree of the parking non-conformity. But that's not an issue as I understand it.
I think this area of Wayne is, there are and this is an area where most of the buildings have no parking or very little. Years back, additions that required parking or more parking were handled as a special exception. That moved to a variance treatment about 10 years ago by this board. But there is a recognition supported, I think, founded in the case law that where you're non-conforming as to parking, you don't necessarily get to ignore all parking requirements, but you have to be allowed enough uses at some level of parking to give you a viable use of the building. For example, if there are uses that require one space per 500 feet, 2 spaces for 500 square feet, 3 spaces for 500 square feet, a reasonable use might entitle you, based on the facts of the case, to the uses which are less parking intensive, like the 1 per 500 or 2 per 500, but maybe not the 3. So it's a variance area that is colored by that nonconformance concept, and there is, I believe the cases very clearly accord some level of protection, but maybe not everything the applicant would want, no matter how parking intensive it is. I don't know if you would disagree with any of that.
I don't think I need to go into it because it's not an issue, but I won't take up the board's time. Unless you need me to address it.
I just, that's been an issue in this area before, which would...
Yeah, I think even in the cases where the board has granted a variance, the variance was limited to that which was over the existing nonconformity, so there was some credit given for the...
No, there's credit given...
for the nonconformity.
Has in the past been given for the nonconformity.
And then the variance was for what the people were over. In this case, there was a determination that they weren't going over the nonconformity that had existed.
And you haven't got a variance request for parking before us anyway, so we don't need to address that.
Right. So I was going to call Joe Birch next from the ownership entity.
Thank you. Sir, if you raise your right hand, do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
I do.
And state your full name for the record, please.
Joseph Birch, B-U-R-C-H.
Joe, by whom are you employed?
S.W. Bages,
And what's your position there?
the VP of Real Estate.
And what are some of your responsibilities in that role?
I look for new properties. I work with acquisitions. I work with the banks. I also work in the development side of acquiring new tenants and also working with the townships. Through the development side, work with various townships and the architects on the plans, and also on the process of through the building and final completion to occupancy.
And the property that's the subject to this application is owned by 100E Partners. Is that an entity that's affiliated with S.W. Bages?
Yes.
And are you a principal with 100E Partners?
Yes, I'm a limited partner within the partnership.
And are you familiar with the property and the general area?
Yes.
And just briefly describe the property in question.
It is a rectangular shaped property. It is just north of the intersection of Lancaster Avenue and North Wayne Avenue on the east side of North Wayne Avenue. It is a one-story, single occupant building. It has a partial basement. It has 3 parking spaces in the back, the patio out front, and the 2 parking spaces in front of that.
And S.W. Bagis is well respected in the area for renovating and upgrading properties in Wayne and beyond. When this property was purchased, what was the plan for it?
We targeted this property specifically for restaurant use.
And was outdoor dining considered at the outset?
Yes. If you look at North Wayne Avenue, although it is not very wide, this property probably has the widest portion of sidewalk in that stretch of businesses. And when this became an opportunity, we thought this was an ideal application for the outdoor dining ordinance.
And that wide sidewalk area, that's where you took some of that area and built the outdoor patio?
Correct.
And that area, though, was not in the public right-of-way. That was on your property, not subject to the public right-of-way for North Wayne Avenue?
Yes.
And what was the condition of the building when you purchased it?
When we purchased it, we thought it was an okay. After a little bit of investigation, we found that the building was structurally deficient. The roof had been compromised by a fire many years ago, and a structural engineer required several other changes to the building.
And have you substantially renovated it before the Zalantro people did their fit-out?
Yes.
Was the ability to have outdoor dining an important factor in the decision to purchase the property?
Yes.
And the work that you did on the outdoor patio, were permits secured for that from Radnor Township to do that work?
Yes.
And patio sounds like a fairly simple thing, but was this particular patio a fairly involved construction process?
Yes. If you look at the property as you travel up North Wayne Avenue, the elevations change quite a bit. I'm sure it is several feet. And at the same time, as you're trying to continue the sidewalk along North Wayne Avenue and then marry that up to the entrance, and in the meantime trying to respect slope required by ADA ordinances and items like that, it required a lot of figuring and a lot of work.
And was this patio built primarily for the purpose to house an outdoor dining space?
Yes.
And do you have an estimation of approximately how much money you spent designing, engineering, and building the patio?
I know that in looking it up today, the concrete work and the railing, including the sidewalks, that cost us $48,500. That does not include engineering, but it gives you an idea of the cost.
And all during this time, you were aware that other outdoor dining had been approved on North Wayne Avenue and other areas?
Yes.
That's all I have for Mr. Birch.
Mr. Rice, any questions for
No
Mr. Birch?
questions.
Anyone from the board have any questions for Mr. Birch? Okay. Your next witness.
That's all I have. I would ask that my exhibits be entered into the record.
Okay. Mr. Rice, do you have anything?
No.
Okay. Are there any comments from the public? Sir, if you'd come up and state your name for the record and be sworn.
Yes, I do. Chris Todd, TODD.
Mr. Todd?
Gentlemen, owner of Christopher's Restaurant, Wayne, PA, right across the street and around the corner from these two gentlemen. I came today because I had an issue with the the zoning board, I don't have an issue with the restaurants, okay? I think all the hoopla they've had to go through for their variance or whatever you want to call it for the outside dining, I'm nervous about it because I have it as well. I think it's very important to the town. And no matter whatever means they've used to get or been given permission to build the restaurants, the main key is that they've invested millions of dollars into the town already. And I'm sure to improve their business as I did with outside dining, it's important that they have it. After listening to everything, all that kind of stuff, I think one thing the board should consider is the good faith issue. Okay, the gentleman back here, we own restaurants, and for years we've been working in good faith, running our businesses with the township in full communication. I think it's very important. We were actually we're working with the township right now with permit issues that we have with our parking, and I'm very happy to hear that you guys are open to new suggestions. And you just raised a very interesting, I'm not sure if I understood it correctly, with the street, how we're allowed to use the entire street plus the metered spots plus the lot. I think that's a big question for us, and I hope we can work in the future together to come up with a great solution for our issues, which the township's working with us right now. But that's really what I mean. I'd hate Wayne to get a reputation of having somebody come in, invest a lot of money, and then all of a sudden be turned away and not be able to improve upon their business. I don't think it's a good reputation we want to construe to to the business world, and that's what I'm looking at is from a business aspect. You guys kind of understand what I'm saying? Am I making myself clear?
Yeah, well, you have to understand, we have a specific portfolio in front of us. We decide cases within a narrow. We don't get to make economic judgments about the community. As
Yeah, I
citizens,
understand.
we may share or disagree with you, but
I understand.
not
Well,
what
that's
we
my
do.
point. Is that when I've applied for my outside permits, I just had to go to review, a design review board, and that sort of thing. I do understand the new issues and how we're
So are
growing
you
in that.
supporting the application, or are you opposing it? And that's really what you're here to do, to testify either pro or con.
Right.
It sounds
on
like
the
you're
appeal.
pro. Notwithstanding, I mean, they're
From a
competitors,
business
but
standpoint, yeah, no, the competition is good. I think the fair market should make the decision of whether they succeed or not with outside dining in the restaurants, just
Right.
as the fair markets I've been competing against for 10 years now. And just on that one point, I think good faith is a big issue as well, which from what I understand is a point now, the way they put their cases.
You have to understand, we don't draft ordinances or determine township policy. We're just here to decide a case on the facts of the case.
All right.
So while we may agree or disagree with your sentiments, we really can't act on those.
Okay.
okay. Anything else?
No.
All right. Thanks very much. Anyone else from the audience? Sir, if you'd come up, state your name for the record, and be sworn.
I do.
And say your name, please.
My name is James Flanagan. I represent Flanagan's Boathouse on North Wayne Avenue. I'm going to let Mike Ellis talk a little bit. Mr. Cutler, I want to understand something because I'm a little confused. Did you not say that the outside metered parking counts?
Sir, are you calling me as a witness?
No.
You don't get to ask us questions.
We don't get to ask you questions?
If you have comments in
Can I sit
support
over
or-
there?
You don't get to ask us questions. I will make my views known at the appropriate point on the evidence that's been heard.
Okay, so we
discuss it.
don't...
You don't get to ask me questions. You get to
Right.
testify.
You can retain Mr. Brosman to give you land use advice.
He didn't say it. I'm going to relinquish my time to Mike Ellis, but thank you, gentlemen,
Okay.
for your time.
Thank you. Mr. Ellis, if you'd state your name for the record and be sworn.
Michael Ellis. I do. Just a statement from myself also in reference to zoning. I own Teresa's Cafe and Teresa's Next Door Bar, which is actually one location on North Wayne Avenue.
Is Paula Coppola here? I'm kidding. She's next on the list.
It's okay. in reference to the parking, again, just as Chris Todd had said, I welcome other businesses. I've been on North Wayne Avenue since 1997. Every other restaurant that's come into town is basically my advertising for me. Just helps people to come into town. We've helped increase the retail business in Wayne enormously from when I first opened. But my comment is, Cilantro came in, got all the approvals to go ahead and open their restaurant with no parking. I have paid to date $62,500 for my parking permits. I have 9 parking spaces behind my restaurant. The only one on North Wayne Avenue with that many parking spaces. If they get open, that's fine. But as Chris was trying to say also, I think you need to look at the current businesses in Wayne. Myself, Boathouse, Christopher's, and Margaret Quo pay for 88 parking spaces for permit. We supposedly use AT&T lot when there's spaces available. That lot has been leased. There's 104 spaces there. They have leased 200 of those spaces out. We are only allowed to use our permits, supposedly, Monday through Friday at daytime usage. Okay, my business, half of my restaurant is closed at lunchtime because there is not enough business for us to be open, and there's not enough parking. Even with our spaces we lease, there's not enough parking for our customers. So I think you need to look at what you're allowing to come in, which is another, okay, White Dog's asking for nighttime and weekends, but still you're looking at another 85 seats you're allowing in, plus Cilantro's indoor seating, plus look at the empty businesses in town. The Wayne Hotel has a restaurant that just recently expanded also that could open at some point with I don't know how many seats. Okay, we're paying for our parking, but certain businesses aren't paying for this parking. So I think you need to decide how this is going to work because we have a very good case right now. Why am I paying so much for parking? That's all I have to say.
Thanks very much. Anyone else? Mr. Schneller? I think Mr. Schneller was previously sworn, so
Yes, I have some points.
he has on the standing question. Jump right in, Mr. Schneller. You're all set.
I see you have 2 different cases to decide on basically the same legal point, and I can't help but think that trying to find a way to read the municipal code as not requiring the required number of parking spaces for any other business is like a needle in a haystack. And I know that we've heard a lot of good evidence, and it's always good to see promises of good business, and there's always a lot of people want to move into town to do business. If there's no parking, there's no parking. And we've got to deal with the comforts of pedestrians and the comforts of people who drive to go to go out to eat and who shop in Wayne. And you know, you can say you're just judging by the law and you're enforcing the law, and I watch you do it every month. But every time you give a variance, you're interpreting the law. And certainly if you interpret...
We haven't been asked for a variance, Mr. Schneller. That's not relevant.
But if...
We know our duty. We know our job. We have to stick to the application. It's very late, sir. Please.
If you're making decisions that are based on substance and you're using your judgment, you're affecting the township every 4th Thursday. So I'm just asking you to give this a careful look. I wanted to mention that this facility has been on notice, I believe, since July of '09, when some kind of resistance did arise to the fact that they had graded and repaved the front of the sidewalk, which had been out of use for almost a century, according to my knowledge. So in other words, that's since 709. I don't think the lease was signed in July of '09. There's been plenty of hankering going on about changes to the lot.
I mean, Matt, was there any violation with regard to the sidewalk or the grading? Are they in compliance?
They are in compliance.
Okay. Not an issue, Mr. Schneller.
I'd like to also mention, repeat the fact that with this number of additional diners, there's going to be this amount of a constructive increase in liquor patrons. Now, the township hasn't had any applications in over 2 years for any new licenses to move in. But
Not an issue, Mr. Schneller, not in this case, sir. Please, it's late. Let's stick to the issue.
I know, but you're looking at a possible estoppel, you're looking at a possible vested interest.
Relating to liquor licenses.
Liquor licenses, we are prohibited from regulating liquor licenses.
Who drinks and doesn't drink, and when and how
No.
and where on licensed premises is LCB jurisdiction?
You're going to be determining on the basis of fact, and if you're giving leeway to someone, try to keep us in mind.
Mr. Schneller, I'm going to rule that line is irrelevant, and I would ask you to move on from it.
Okay, well, even if limited to parking and traffic, in the busy evenings in downtown Wayne, we need help. And finally, in regard to the vested interest, either that or the estoppel matter, we've heard claims or semi-charges that the township has changed course. The township is suddenly enforcing a law that shouldn't be, or that this vested interest and no enforcement should maintain. Well, the fact is, if it's 2 seats here and it's 2 seats on the sidewalk there, and it was a different manager and a different director of community development and zoning officer, perhaps when a 50-seat or a 34-seat dining area opens, it's a good time for the township to start enforcing. I think there's no interest there that was that has put the township in some kind of bad light, and I don't think that it's selective enforcement. That's it. I hope you'll keep this in mind. And I have a question, a technical question. Is a person without standing permitted to file a brief?
No.
Well, you couldn't send it back to me, though, could you?
I'm sorry. I'm not
If I
understanding
put
the
it in
question.
letter form, wouldn't it have to go in the file?
You'll just be killing trees for nothing. We can't keep you from writing one and sending it in, but it won't be considered.
Print two-sided.
Won't be considered.
Thank you, Mr. Schneller. Anyone else from the audience? Okay. Do we have Mr. Rice? Anyone from
Nothing else.
any members of the board have any comments?
Yeah, I do. I'd like to draw a fine point on all of this and see where we are. You know, again, for anybody in the audience, and Mr. Schneller included, our brief is strictly to deal with the code as written, interpret it in what we think is a reasonable way given the facts of the case and what its issue in the appeal. And that's what we do. We don't determine parking policy in Wayne. We don't write ordinances. We're not the Board of Commissioners. We don't pass legislation. We're neither the executive nor the legislature. We're a quasi-judicial body. We hear cases on the facts of the case and deal with the code as it is. So some of you had some valid things to say, and it was certainly interesting, and as a local citizen, I care about what you're saying. But as a member of this board in this matter, this is not something we can consider. Is Wayne underparked? Maybe. Is it a problem? Probably. But we're not solving that today, nor do we have the authority or power to even consider that. So keep that in mind when I talk about this. Now, I'm going to try to summarize how I've analyzed this and see how the other board members think, and we're going to have our discussion right in front of you and see where it goes. It's my belief, on looking at the code as a whole, that certainly I can infer from this that the Wayne Business Overlay District was considered different because it's like a downtown area, and there's lots of street parking and metered parking lots in the area, and a lot of properties that don't have off-street parking or have very limited off-street parking capabilities. So it seems to me that what's happened here is that they've provided for satisfying the parking needs either by on-street parking, which is defined for the purpose of the overlay district as being parking on the street that fronts the property. But the definition is right here, on-street parking, quote, the space for the parking of an automobile located on the street in front of a building. That's the definition that's in the code. We don't write the code, we read it, okay? So now there's also other metered parking in Wayne. So I think in this case, the presence of on-street parking supports the application. Because the parking is there. Now, it even says in the code under 513.12, on-street parking, where on-street metered parking currently exists, which it does, parking shall remain on-street to the maximum extent possible. There's lots of reasons maybe. The reason that comes to mind right away from my perspective is we don't want more impervious surface than we normally, than we can get away with having. So you don't want to pave too much area and create worse runoff and stormwater problems in Wayne. So where on-street parking exists, we want people to use the on-street parking. If you don't have it and you're at off-street parking, as in the prior case we heard tonight, it's a different issue. Then there's the formula. This formula only applies to off-street parking. It does not apply where on-street parking exists under Section 5312. So in my opinion, as a member of the board, and we haven't voted yet, is that this application meets the parking requirements as a matter of right because of the on-street parking. Plus, we all know there's also a metered lot that runs off of the street as kind of an extension of the street. So I believe it's not an accessory use, it's a principal use because of the way it's defined for a restaurant to include outdoor dining as a principal use, and that the parking requirement is not an issue because of the on-street parking. That's, so I would grant the relief on those grounds, not necessarily how it was asked for in the application.
I would like to, frankly, see some briefs on that point.
Yeah, again, first of all, doesn't the property have a space or two, or is it totally devoid of parking?
I think the testimony was it had three spaces in the back.
It has three, so it has some on-street parking. I think that
off-street, you mean?
I mean off-street.
Has both, but it says you're supposed to use on-street as much as possible. It favors that under A.
Yeah, but I think that is part of this. This is a fairly complicated series of ordinances. They have to be read together. And I've heard some ideas formulated. I've got some concerns, but I really think that because of the importance of this, and in fairness to all the parties, there ought to be briefs. And I would ask that the records recommend that the board hold the record open in this appeal, as with Appeal 2854. On the same briefing schedule that we had the last time, namely that everybody's briefs but the applicants are due by Monday, June 6th at 5 p.m., with Mr. Brosman having the right to supplement his brief by 5 p.m. on Monday, June 13th. And it will also give us time to walk through, and the board time to read the code, to consider this. The cases may go off differently, they may not, but they have they're construing the same set of zoning provisions, and I think that to give fairness to the parties and to enable this board to best do its job, including my job as in reviewing the materials and offering you what thoughts I may have, I think this case should be put on the same footing as Appeal 2854.
Okay, I agree. Are there any other comments from the board? Peter, do you want to have a comment?
I'd like to ask Mr. Ellis a question, if I could.
Mr. Ellis, if you could come up.
You testified that you're paying parking fees. I think you said $62,500.
He pays to lease spots.
To date,
I assume that wasn't something you just volunteered to do.
No, that was ordered by the zoning board.
Can you explain to us what prompted you to enter into that arrangement?
Back when I originally was opening my first side of my restaurant in 1997, I came to the zoning board with a signed lease and a business plan of what I was doing. And basically the zoning board at that time said I would need to lease 20 spaces for the original side, which was 60-some seats at that time. About 4 years ago, I came back when I did an addition to the restaurant, and I was told I needed to lease another 18 spaces for the addition to the restaurant, which is directly next door, which includes the seats and the employees. And then also, so I'm leasing a total of 38 spaces now. Back when we originally started in 1997, we leased those spaces from the Wayne Business Association at the AT&T lot at $10 a space. Radnor Township took that over in 2000, doubled the price to $20 per space. Currently, Radnor Township is looking at increasing that fee again to $45 per space, which will put me over $20,000 per year.
Per space per
parking space at the AT&T lot for a permit.
What?
45 a space, you said?
$45 per space for
month,
us.
Per month, per year?
Per month. per month. It will cost me over $20,000 per year
For all
for
those
permit
spaces.
spaces for my business.
Isn't
And
it
that
true
lot
that
is
this ordinance
overleased.
didn't exist then? The Wayne Business Overlay was, what, November of '07?
Correct.
So, I mean, your
Well-
situation wasn't governed by this ordinance at that time.
It was when he did next door, right?
No,
I thought it was
1997, I had to go to the zoning board
That was
Right,
4 years
but-
ago.
for
Right.
relief.
Right, but when did you open next door?
We opened 2007.
Okay.
it was.
So they would have been in for permitting early in 2007.
I don't have the exact date. I'd have
Right,
to
it
look that up if
wasn't.
that's for you.
No, it
Teresa's
wasn't.
next door was not in place when the overlay district, or was already in place, excuse me, when the overlay district came into effect.
Yeah.
Okay.
So this ordinance was not, played no role in what you went through. This is a new ordinance recognizing the special status of.
So I could come back and try to get relief for
I
mine on
can't
it.
comment on that. I can only
Okay.
comment on this case.
Okay. I mean, this affects us desperately. I mean, we're going from, originally I used to pay the Wayne Business Association, and in all honesty, we didn't get charged from the Wayne Business Association when I first opened for 20 spaces. Township took it over. Now the township leases this lot for $1 per year, but they are charging us $20 per parking space per month. They have overleased that lot. There's only 104 spaces there. They have overleased it to approximately 200 spaces, I believe.
Yeah, that's very close, yes.
And then there's also other permit lots, Llewellyn Avenue, Windermere Avenue, that are permit lots that are also leased, and I'm not sure if they're overleased, but I believe they're at least full.
But I mean, this is a discussion you should have with the commission, the Board of
Okay,
Commissioners.
but this is something, well, this was done through the zoning board, that I had to lease these spaces.
They were
not-
conditions of approval?
Condition of approval for my business.
Based upon a different law at a different time.
Okay.
But we have to deal with the law as it is, and the
That's fine.
application as it is.
I was
Yeah.
asked to come up
But I mean,
with comments,
that's who writes these laws and can change them.
Okay.
and-
I just want you to take in consideration what they're asking for here, which is, well, 85 seats outdoor. And then there's Great American Pub that has approximately 50 seats, and then throughout the town there's more, plus other businesses that are currently vacant.
I'm aware, I mean.
They're only looking for 35 seats outdoor.
The free
right?
market
34?
is going to decide who
And White Dog,
survives.
too, I'm sorry, combined,
Oh, yeah,
sorry.
I get it, yeah.
And again, I have nothing against it. I think it's good. I'm approved for outdoor seating. I don't do it currently because it's very small. But I just think that, the current situation in Wayne is become very desperate, and there's inequities between who has to pay and who doesn't have to pay, and it's just, I understand things have changed. So,
Thank you.
I don't know if there's any other questions.
Any other questions for Mr. Ellis? Thank you.
Thank you.
Yes, please.
I'll be brief. Thanks for the board's patience. You could take notice of the decisions that you made, but I had reviewed them with regard to Mr. Ellis's business, and it looked like to me, and you could check it yourself, I don't want to get off on a tangent, but at the time, he was asking for, he had a certain level of nonconformity, as the Cilantro people did, but he was then asking to increase that, and he was asking for either a special exception or a variance. And I think it was based on that variance or special exception for the new parking he required that they either proposed or were required to enter into that agreement. And that's the basis that they got in before the WBOD. So it is a different circumstance than ours. We have no issue with them changing their arrangement. We don't think it's particularly relevant to our case, but I didn't want you to think there was some inequity that should affect our application based on his situation.
Okay.
The other thing I'd like to say is we have to, are you going to file a brief in this case too, John? Are you doing both?
Haven't decided.
Okay.
At least the first one I will. I think the same basic issue is there, so the facts are a little different, but whatever I file, I suspect it'll cover both of the cases.
Okay. Is there some concern, and we appreciate this is a job you're doing, there's just some concern with Cilantro that they could move ahead as quickly as possible. We understand you have to analyze this, but I was just checking if you weren't going to file a brief on this one. Did we need to extend? And the other thing, it's probably more of a question for Matt, but we were on the agenda for the Design Review Board in June. We understand that that's just a step we have to take, and that's we'd have to get the approval here, but we would like to stay on that agenda.
Why is that part of this hearing? Why are we talking about that?
Because they're continuing us, and
Well,
I
but
was
that's,
just asking Matt, I guess, is that something we could talk to you about, if we could stay on that agenda?
why don't we discuss that after this hearing's closed?
Okay, that's fine.
I mean, why is that being,
Just because
it's
we
an
were-
administrative question. It's not for this board whether you go to the design review board.
That's why I was asking Matt.
All right.
I agree, it's not for them, I was asking Matt, but since the
Well,
continuance came up.
Let's close this hearing now.
Okay.
Is there anything else?
We're not going to close the hearing or the record. We're going to continue it, and I'd like to have the, same, continuance, acknowledgement that the hearing's being continued till June 15th, and our, time for rendering a decision is 45 days after that.
Well, is there a reason to continue the record? I just get briefs, right? Why do we need more testimony? They put their cases on.
Well, I guess if the, we wanted, I think the other case people wanted to keep the record open.
Yeah, but it's different. You had protestants and things like that. I mean, there's nobody who's appeared, just the township and the township's here to put on any evidence it needs. So why keep the record open? That means they have to drag all their witnesses back, because somebody may want to, recall them.
What do the parties
Well, they
have
could
to say
move.
about
They could
this?
move to open the record, couldn't they? The
Yeah,
next proceeding?
I don't expect it, I mean, we don't intend to put on any testimony in either of these cases, so unless George has something in mind.
And if something came up, he could make an application, right?
Right, if you close the record tonight on either or both of them, then you got 45 days from tonight to render your decision. You're going to have
Unless it's
briefs.
extended by the parties. I mean, I want
Right.
the 45 days to run from June 15th, not from tonight. June 16th, whatever the date is, it's June 16th. I want the 45 days should run from then. These are we have to go through this. This is not a 101B1 special exception.
No.
And I understand everybody's desire to move quickly, but it's been pushed quickly on us by circumstances, not of the applicant's doing, but still, we have to have our time to do it. Also, I think that since the legal issues are very similar in the two cases, that for decision-making and briefing anyway, they should be kept on similar tracks.
Yeah, I mean, the only reason we're questioning it is, under the ordinance, outdoor dining is only allowed it's only allowed through April through September. And, we're continuing this, which I understand why. It could be June, and then there's going to be 45 days July. Then if we don't get to the design review board, that could be August, and we've lost the whole year. Just seeing if there's any way to avoid that in this case.
I'm just not comfortable. The application came to us when it did and in the form that it did. I'm not blaming anybody for that, but I'm not willing to recommend squeezing the time the board should have. The two cases are the same legal issue, and I mean, I would strongly urge that the continuance be agreed to, if not being in a position of having to impose it on everybody, which we could do. We could just simply continue the hearing and leave the record open if people needed to do that.
That's fine. We agree to that.
Okay, and for 45 days from the date of what is it, the 16th is the, what?
I think we said it was the 16th was the
Whatever.
hearing.
Yes, okay. Is that all right with the township?
That's fine.
Okay, fair enough. Jim? I think we're in agreement that we just continue the hearing, except I think the parties are in agreement that unlike a 2854, we won't leave the record open, but we'll take briefs.
Okay.
But the 45 days will begin to run from the hearing on the 16th. The decision, the 45 days to render the decision will run from the 16th.
Are you okay with that?
Yes.
Okay, then we'll go that route. Okay. And so we're closed, and we'll see everybody in June. Thank you.